All right, good morning, everyone. This is the staff attorney. Welcome to our civil calendar for Thursday, April 3rd, 2025. Judge Krause will be with us momentarily. I see a number of court reporters are with us today as well, so please be sure to let the judge know your presence. We have a number of pretrial conferences and a couple final hearings and some motion hearings. When the judge comes on, she will call for announcements. Please give your time announcement and what case you're here on. And she will then decide the order in which we're going to go. Don't forget to unmute when your case is called. And when you are not talking, please remember to mute your microphones for the benefit of everyone else. All right, I expect the judge to be on with us any minute now. So hang on, we'll get underway.
Okay. Good morning, everyone. Sorry for that delay. I was having some technical difficulties. So we have a number, as you can see from all the people here, we have a number of matters to take up, although I think we can probably get through some of them more quickly than others. So I'm just going to call the calendar real quickly, figure out how long we think things will take, figure out who's got a court reporter for takedown, and then I'll figure out sort of where we're going and in what order. Boy Wonder versus Brickell Investment Group.
Monica Teasley for Who Runnings, the defendant, a third party defendant.
And
Okay.
Judge Ethan Pugh here for Brickell and Gabrielle Padone.
Okay. And I know from your briefing there was some you'd had some difficulty being in contact since December with Mr. Mzikewe. Have you been in touch with him, or were you expecting his appearance here today?
We haven't heard from him in some time. We sent him, I know we were talking about service issues on our last call. We sent him an acknowledgement of service, but we haven't heard anything from Mr. Mzikewe since.
Okay. If you guys will sit tight, we're going to give Mr. Mzikawe the benefit of the doubt and that he's just being delayed in some manner. Maybe he had technical difficulties like I did. So if you guys will just sit tight, I'll come back to you either when Mr. Mzikawe appears, or if he does not, then we'll discuss what happens then. Okay.
Thank you, Judge.
Thank you all. Michael Pardo versus Oswin Dealey. I believe, I don't know if anybody's on the call for that, but that was an announced resolution. We were just waiting on them to file a notice of settlement. Is anybody here on that case? No. Okay. Jason Walker versus MARTA.
Good morning, Your Honor. Gabriel Kingdom for the plaintiff, Jason Walker.
Okay.
Good morning, Judge Carlos. Nicole Shockley on behalf of MARTA.
Hi, Ms. Shockley. Seems like we've been seeing a lot of each other these lately.
We definitely have.
Okay. So what is the status of this case? I don't see that I had received a pretrial order for this matter.
Judge, you did, and that is entirely on me. I put it in the wrong folder, so I've just sent it to you.
Okay. Technology is getting me today, apparently. So in any event, Mr.
Kingdom.
Sorry, Mr.
Yes.
Kingdom, thank you. I had written down Kingdom, and then I thought, did he say that was his first name or last name? Mr. Kingdom, what is the plaintiff's position in terms of readiness for trial, and how long do you think it will take to try your case, sir?
Yes, so plaintiff is ready for trial. We anticipate it being 2 days.
Inclusive of jury selection?
Yes.
Okay. And Ms. Shockley, what about MARTA?
I would estimate about the same.
Okay. You mean in total, not in addition, right?
Yes. And then
okay.
I don't know if this addresses more than part of the question. We also have mediation scheduled for the 22nd.
Okay, excellent. So the case is actually on the count. I think I saw that y'all also have a deposition scheduled today. So,
Yeah.
Your mediation is on the 22nd, and if it does not resolve, then I believe my first trial day that week is the 29th. So it would be that Tuesday of April for trial. Other than I will now review your consolidated pretrial order. I'm certain that it is fine. Were there any specific issues that y'all wanted to bring to the court's attention, other than, the standard type things that y'all would, relate to me in a consolidated pretrial order?
And on the plaintiff side, it's just one repair invoice for his vehicle that we left off the pretrial order. I emailed it to defense counsel this morning, and if she doesn't have any objection to the $2,000 bill being included in the pretrial order, I can re-email it to your staff attorney.
Okay. Well, rather than putting Ms. Shockley on the spot, I'll tell you that I'll save both of you a little bit of trouble, which is the one request I do have typically after I get your CPTO is that all lawyers tend to do their the part of the CPTO that calls for exhibits. They tend to say, medical records, repair records, and then that, my personal favorite, any document anybody produced in discovery, right? Which is fair. I understand why you're doing it. But what I do ask is that actually before you get to trial, that you provide me with an actual itemized list. It's obviously you're not going to offer into evidence typically anyway. People don't say these are her medical records. It's, these are the records from this provider, exhibit 1. That would be very helpful to me. And I suspect that you can address that issue with the invoice in the process of doing that. Are there any witnesses that y'all anticipate would need to testify remotely? And if so, is there agreement among the parties to do that?
There's the doctor, the treating chiropractor. She's busy, so we would like her to be interviewed remotely.
Okay. Ms. Shockley, you don't necessarily have to agree or disagree with that just now. It's mostly just let me know if you have a strong opinion one way or the other, if their parties are in agreement. We have full availability to provide you with Zoom access. I have witnesses testify routinely by Zoom all the time. So we're able to accommodate it, but the parties have to be in some agreement. Otherwise, I'll have to hear that issue and deal with any objections. Anything else, Ms. Shockley, from MARTA's perspective, other than just, here's our CPTO?
I don't think so at this moment.
Okay, excellent. Well, thank you both very much. I will be in touch. If you do not announce resolution resulting from the mediation, then what I expect you can probably look for is that I'll be in touch either the Friday or Monday before you're set to go to trial, for us to have, maybe an hour-long conference by Zoom to go through those sort of pretrial issues that if you don't do it, then what tends to happen is we get there on Tuesday morning and then we spend the whole morning going through those pretrial things, and then the jury's all mad because they've been sitting there all day and they only get called into the courtroom around 1 o'clock. So y'all can expect that I'll be in touch if you do not announce resolution for, as I said, just about a 1 hour pretrial conference to deal with any motions in limine, any exhibit issues, things like that, right before the trial date.
Excuse me, can I ask one clarifying
Sure.
question to that? So I know in the actual order, it tells us to submit our motion in limines and things like that prior
Yes.
to trial. So
Yes.
is it just assumed that we'll be called on that day? So that's why we need to submit it before that date, or?
Well, actually, I think my scheduling order says you're supposed to submit motions in limine 2 days before the pretrial conference. But I understand trial lawyers are busy. I understand as people are preparing for trial, new issues arise that they might want to raise a motion in limine about. What matters is that when we have a conference call, you either have submitted it to me in writing or are prepared to raise those motions at that time, even if they're done verbally, so we can have a conversation about it.
Okay, so once we get notice of the call, that's when we need to make sure we submit it before that.
Exactly.
Okay.
But yes, we have to trade off jury days. This is just for everybody's benefit if you're going to try a case in front of me. So the week of the 28th is my civil trial week calendar, and the day that I have jurors, that is the 29th. So you can expect that if your case goes to trial and isn't behind other cases, which right now it would not be, then it would be on Tuesday, the 29th would be the day that we would select the jury and start the trial.
Okay.
Okay. Thanks
Thank
so
you,
much.
Judge Price.
Thank you.
Ms. Shockley, Mr. Kingdom, you're free to go.
Thank you.
Thank you.
Okay, Sunil Saili versus 100 Holdings, although I think 100 Holdings has been excused from the case. Who do I have here on that matter?
Good morning, Your Honor. Matthew Wilkins for the plaintiff.
Okay.
Good morning, Your Honor. Kurt Lentz on behalf of 100 Holdings. 100 Holdings is one of the defendant entity, or the only defendant entity that is still in the case.
That still is in there. Thank you.
Right.
I appreciate that.
I take that back. I think Marion Partners is also still in the case. I saw Matt reacting down there. So Marion Partners and 100 Holdings. So I'm here on behalf of both of those defendant entities.
Okay, so what I was advised of yesterday is that the parties had requested a trial continuance because y'all believe you might have hashed something out that would resolve the case, but that I think the request was for 30 days to either dismiss or substitute in a new plaintiff. Is that roughly accurate?
Yes, Your Honor. So this is it's a promissory note case. Ultimately, my client has now sold and transferred that note. So we are no longer the real party in interest. The party that now would own the debt either needs to be substituted or would simply tell us to file a dismissal without prejudice. So one of those two things will happen in the next 30 days. But since neither Mr. Lentz nor I can represent that individual, we can't give you clear advice on what that individual will do today.
Okay, and that's absolutely fair for today. I think my issue is the case is supposed to be on the trial on a non-jury calendar for the week of April the 28th. And so obviously if there's a new party substituted in, we might have to have some conversation, although, if it's really just an assignee situation, the facts wouldn't have changed. But of course, that person might have different ideas about how they want to pursue their case. And that's fair, and I understand it. But if there is a potential for a dismissal, I don't know why we wouldn't, instead of doing 30 days, just target it for that date of trial, because either it's going to get dismissed or y'all are going to tell me, hey, there's a new plaintiff. And so can the plaintiff have some additional time to be ready for trial? Although admittedly, barring y'all telling me something really interesting and unique, I don't know that I think that new plaintiff would be entitled to a whole new effort of getting the case ready for trial. But certainly some accommodation for them being in the case and having the ability to familiarize themselves with it and decide what route they want to take strategically.
And I guess without sort of divulging too much, I mean,
Sure.
the purchasing party knows exactly what's going on.
Okay.
There's no surprise. We're not talking about new discovery, new defenses. We simply need to have the ability to have that person tell us exactly what to do. And so that's why we had asked not that the case be continued indefinitely, but that it got pushed back by, a month or 2 months to the next trial calendar so that now this person can make that decision. But
well, and forgive me for interrupting you, Mr. Wilkins. I understand all that, and I don't mean to imply that I think your request is unreasonable. It's just that this is a pretty old case, relatively
Understood.
speaking, and it is set for trial for the week of April the 28th, and it is only the 3rd, so that's still 25 days, which is almost the 30 that you asked for.
Understood.
So what I would like to do is have the parties either dismiss or announce what we're doing relative to proceeding to trial by the 28th, which is that civil trial week. If that would, I think that would give you a little bit of time. And of course, if there's some particular unique issue, you can still reach out to the court and we'll consider what you request.
Of course.
But just based on it, the request that I've got so far, it seems to me that y'all hopefully should be able to make those decisions by the 28th and decide if it's going to be a dismissal or something else.
Okay, no problem.
Anything to add from the other parties who are here?
No, nothing from the 100 Holding and Marion Partners defendants. It is a unique situation, but for reasons related to a TRO that's going on in Texas that touches on this, I want to be careful of how much I say. I mean, if it was a Facebook status, it would say it's complicated. But for purposes today, I think this is, I have nothing further to add.
Well played, Mr. Lentz. I like that one. Anything else from any? I think there was one other party that was here. Okay. Okay. So it looks like Mr. Sweat, there you go.
Yes, ma'am. Your Honor, I'm here just supporting Mr. Lentz with the 100 Holdings defendants. Nothing else to add.
Excellent. Well, thank you, gentlemen. I will look for whatever your further announcement is on the 28th. And then if it's not a dismissal, we will all be in touch figuring out where do we go from there. Okay.
Thank you very much.
Thank you all. Have a good day.
Thank you. Bye.
Kahinde Busari versus Cantilever Architectural.
Good morning, Your Honor. Sabrina Leverett here on behalf of the plaintiff.
Hi, Ms. Leverett. And do we have anybody here? I know, do we have anybody here on behalf of Cantilever Architectural and Warren Deli?
I do not believe so. And these are now pro se defendants, Your Honor.
Okay. So obviously, Ms. Leverett, the court has already granted a partial summary judgment in your favor. I have yet to enter the order. Thank you for sending over the proposed order. I just need to review it. And I've been presiding this week, so I've had a little bit of other stuff going on. But I will have a chance to get to that and get it on file. And really what needs to happen is we just need to schedule a damages hearing in order for you to present. And mainly it's because as my recollection of reviewing the file is that it's not really a liquidated damages case. And to the extent it is, it's not pled that way in the complaint. And I don't have that information factually in front of me. And so I need some evidence from you regarding the nature of the damages that were incurred so that the court could potentially enter a final judgment. How long do you think that would take, Ms. Leverett, for you to do that and call a witness or submit an affidavit or whatever it is you'd like to do?
My client should be the only witness. I don't see why this should take more than 15, 20 minutes, maybe.
Okay.
Yes,
so I am going to be out of town next week.
Okay.
And so the most likely time that it would be rescheduled would be the week of April the 14th. But we'll see about getting you on the schedule, and it would just be a quick hearing at, say, 9 o'clock in the morning sometime that week. Would that work for you? It would likely be on a Thursday, and we can do it later. I just, you have a partial judgment. I thought you might like a final judgment, so I'm trying to get you one scheduled as quickly as I can.
Thank you, Your Honor. The only day that does not work is the 16th. I do have a conflict for the 16th.
Okay.
The
Well, I think the 17th looks like it would work for me. So we're going to tentatively look at the 17th at 9 a.m. And I will, if that won't work for us, we will let you know. But otherwise, we will issue a notice of a hearing for you for that day. And it'll just be by Zoom.
Thank you, Your Honor.
Okay. Thank you, Ms. Leverett.
That concludes my matters with the court. May I be excused?
Yes, it does. You may. Thank you. I don't think I have anybody here, but just in case, on the Hari Krishna Roswell Hotel versus Michael Scott. Okay, just making sure. CLM Trust versus Brett Pavle.
Good morning, Your Honor. Brad Fallon for the plaintiff.
Hi, Mr. Fallon.
Hi.
Morning, Your Honor. James Carroll for the defendant.
Okay, where are we?
Well, my understanding is my client is going to file a Chapter 7 bankruptcy soon. And I'm going to withdraw. He's no longer been in communication with me other than just stating that he's going to file this bankruptcy.
Okay. And that your client being Mr. Pavle, because
Yes,
the
he's the
only
only
party
one.
left at this point, right?
That's right.
Okay.
Parties are, one has been dismissed and one has filed the bankruptcy itself, and then also
Correct. Okay. So Mr. Carroll, if just to be clear, if you are, so the case is set for trial. Granted, it's not a hard April the 28th because it's a non-jury trial, at least at the way it's currently listed. And so basically what I would be looking for you to do is to either, for both you and your client's benefit, as I'm sure you know, if your client's going to file a bankruptcy, that doesn't change the outcome of his needing to be present for trial unless he has filed a bankruptcy. Number one, and number two, if you are no longer going to be representing him, then I don't want to unfairly look to you if you are not in good contact with your client. And so if you've not filed a withdrawal and that is your intent, I would suggest that you do it sooner rather than later.
Yeah, I'll do it as soon as I can. I've been trying to get in contact with him and seeing what it was, and the only word I've gotten back is that he wants to file bankruptcy, but I don't know the exact timing on when that's going to be.
Understood. Mr. Fallon?
Yes, it was just going to be a simple bench trial on this promissory note, and that I just found that up today, so we'll see how that goes. There is the related case against the one ex partner / CFO that's also on the exact same note that ended up in a different case because his default got dismissed.
Okay.
And so we have that it's just been kind of sitting there because the real party was the owner, and until about 10 minutes ago we thought that was the main one.
Okay. Is the other matter that's associated with this, is it also assigned to me?
Yes, it's
Can you give me that?
00753.
I'm sorry?
24 or 7523. 7523.
Okay, thank
24.
you. Okay. So I'll make a note that those, if they would, I mean, obviously I'm not consolidating them officially, but just I'll make a note that they need to travel together, that they are in fact related if our system doesn't reflect that. Ultimately, as I said, the week of the 28th, typically, if I don't end up going out on a bench trial, what I would typically do is notice you guys for like a Monday or a Friday for a Zoom. We can do it in person if you prefer, but if it's one of those sort of half day, let me call two witnesses because it's a promissory note, then it's typically something we would do by Zoom. And so, Mr. Carroll, my guidance to you would simply be, as I said, I'm going to keep it on the calendar because that's what it's noticed for. And if your client files bankruptcy, obviously provide us with notice of that, and then the stay would follow automatically. But in the interim, if there's a concern that your client might not file bankruptcy, I don't want to be unfairly, again, looking to you for answers if you don't have answers to give me. And so I would just encourage you by the 28th to have figured out if you're going to stay in the case or not. And then, advise your client that if he's going to file bankruptcy, he needs to have done so by the 28th, or else the case will go forward.
I understand, Your Honor. I'll definitely file my notice of intent to withdraw before then, and I'll advise my client of the withdrawal.
Okay. Excellent. Well, we will wait to hear from y'all regarding the possibility of a bankruptcy and Mr. Carroll's withdrawal. And otherwise, we will generate some, we will be in touch. We've already generated the notice, but we'll be in touch with you regarding the exact timing of whenever this matter would be set for trial. Okay.
All right. Thank you, Your Honor.
Thank you
Thank
both.
you,
Have a
Your
good day.
Thank you.
Zachary Higgins versus the SORB.
Morning, Your Honor.
Hi, Mr. Pines. How are you?
I'm doing well. We're here, we're ready. I spoke to Ms. Crowder. We don't have a court reporter, so we can talk fast. And we believe we could probably get this done in an hour total.
Okay. Okay.
Right, Ms. Crowder?
Yes, Mr. Pines. This is Elizabeth Crowder on behalf of the Sex Offender Risk Review Board Judge.
Thank you, Ms. Crowder. Okay. I am going to move on and then figure out what else I have in terms of takedown and figure out how to schedule everybody so that I'm as efficient as I can and let you guys multitask. So stand down for just a moment and I'll let you guys know when we're going to start. Okay.
Good. Yes, Your Honor.
Thank you, Judge.
Thank you. Galen Vick versus Reverse Logistics.
Morning, Your Honor. Ramsey Knowles and my colleague Jordan Davies, she just got married, are here for the plaintiffs, or are here for the defendants in this case, excuse me.
Okay. And do I have anyone here on behalf of the plaintiffs?
Good morning, Your Honor. John Strauss. I'm here on behalf of the plaintiffs.
Okay. I have got summary judgment motions pending for Reverse Logistics Trends, Reverse It Sales and Consulting, Reverse It Logistics Association, and the NRF. I think the only summary judgment motion I don't have a defendant from, the only defendant I don't have a summary judgment motion from is Mr. Ciarata, whose name I'm probably mispronouncing. But how much time do you have a court reporter, and how much time do you believe that it will take for this matter? Understanding that I reserve the right to say, no, you have to do it in a shorter amount of time, but.
Yes, Your Honor. I think we'll need about 20 minutes,
Okay.
Notwithstanding all the different motions. I'll explain why we filed so many different ones. If I may correct you, one of the motions does include Mr. Shirota.
Oh, is that the one with, is it Reverse It Sales with all the sort of the other, okay. I may just have
Kind of catch all, yes, ma'am.
I apologize. Okay. And
Yes.
Mr. Strauss, do you agree with that assessment, sir?
I was thinking probably the total would be close to 30 minutes total.
Okay.
And we do have a court reporter.
Excellent. Thank you. And who is the court reporter for this matter?
Amy Johnson.
Hi, Ms. Johnson.
Hello.
Just let you know when I'm ready to go on the record, I will officially call the case and then ask for announcements for them just to make your life easier so you know exactly where to start. Okay.
Thank you.
Thank you. Ironside Homeowners Association versus Ironside East Atlanta, and then also Ironside Homeowners Association versus Thrive Construction.
Good morning, Your Honor. Chris Reading for Ironside Homeowners Association. Also, Rich Capriola is on the call as well, for the Zoom as well.
Okay.
Your Honor, Bernie Kistler for the defendants, all three of the defendants, the Thrive and the Ironside entities.
Okay.
Brickell for Atlanta Metalworks, one of the defendants named in this matter.
Okay.
Your
Now,
Honor,
oh, sorry, go ahead.
Mary Margaret Nolan on behalf of Exterior Traditions.
Okay.
Marilyn Yingling here on behalf of Structurally Sound Georgia LLC.
Okay. Okay. So this is actually on the calendar on plaintiff's motion for sanctions against the Thrive entities. How long do you think that your presentation will take regarding that matter, Mr. Reading?
Your Honor, I would estimate, I think we intend to argue the motions together, and I would estimate between 20 and 30 minutes. Probably closer to 20.
And Mr. Kistler, you'll be handling the response to those motions?
That is correct, Your Honor. And if his presentation's 20, I would think mine would be probably 10.
Okay. Thank you. And do y'all have a court reporter?
We do, I believe it's most
Is
likely.
Houston? I think I just saw her raise her
Yeah.
hand.
Yes, ma'am.
Thank you. Okay.
Your Honor, this is Sean Hines. I represent the third-party defendant in the Ironside versus Ironside case. And we don't have any argument or role as we see it in this motion.
Is that Mr. Garcia?
Yes.
Okay.
And I didn't know if it would be, I've got some deposition set and just wanted to get permission from the court to be excused from the hearing.
I promise not to take any substantive action against your client on this motion for sanctions.
All right. Thank you. So may I be excused if we're not?
Yes, sir. Absolutely,
All right.
Mr. Hines.
Thank you, Your Honor.
Okay, and then I have Rennie Bulbekian. I apologize if I've just butchered that name, versus the estate of Richard Heyman.
Yes, good morning, Your Honor. Attorney Monica Gilroy, on behalf of the defendants, Michael Austin and PJ Austin.
And
This
who do
is
I
my
have?
motion to, good morning, this is my motion to dismiss. I have a court reporter here, Ms. Reed Hicks, and I think my part will take no more than 15 minutes.
Okay, and
Good
who do
morning,
I
Your
have
Honor.
on behalf
David
of the
Perry.
estate? I'm sorry, on behalf of Mr. Bulbekian, and please tell me how to pronounce that.
It's Bulbekian.
Oh, okay, I get a gold star then.
Yes, ma'am. And I'm David Perry.
Okay, and do you agree with Ms. Gilroy's assessment regarding the amount of time?
Yes, ma'am.
Okay, thank you.
And Your Honor, on behalf of the estate of Richard P. Heyman, Jordan Foreman,
Okay,
I'm not even certain that I will present, but if I do, I would think 5 minutes or less.
okay, thank you. And 4370 Perrin Place versus Cameron Buckler.
Good morning, Your Honor. James Johnson for Cameron Buckler.
Okay,
Good morning, Your Honor. Yaksha Hideri for the plaintiff.
okay. And I have a motion for summary judgment based on failure to respond to requests for admission. I have a motion to withdraw the deemed admissions, which were accompanied by a motion, or excuse me, by a set of substantive responses. And then I also have a motion to dismiss that I think might have been filed by Mr. Buckler when he was pro se. Mr. Johnson, can you tell me if that's a motion that you're adopting or if we're just going to put that off to the side for now?
I think we're going to put it off to the side.
Okay.
To the side.
That's kind of what I thought. Just wanted to make sure.
Sure.
Okay. And how long is it that you believe it would take, Mr. Johnson, for, or excuse me, I'm sorry, Mr. Hidari, for your presentation regarding the motion for summary judgment?
Our motion for summary judgment, as well as the case itself, is relatively simple, Your Honor. So I would think about 5 to 10 minutes.
Okay. Mr. Johnson, you agree?
Less than 5 minutes. Yes, Your Honor.
Okay. Okay. Well, given that very short announcement, do you have a court reporter?
We do.
Okay. Who's your court reporter?
Hi, this is Ebony Haseleger.
Hi, Ms. Haseleger. I'll just make that note.
Thank you, Your
And
Honor.
okay. So given that very, very brief announcement, while I'm at it, let me take a moment real quickly and ask, is Mr. Mzikewe here or anybody on behalf of Boy Wonder? Okay. Given your very short announcement, Mr. Johnson and Mr. Hidari, I'm going to go ahead and call your case first. And Madam Court Reporter, this is going to be a hearing on a motion for summary judgment in the matter of 4370 Perrin Place LLC versus Cameron Buckler, case number 2023 CV 390343. Let me start by pointing out to you that I have read both of the motions and the supporting materials. I'm familiar with the background of the case because y'all have been in front of me a couple of times. And as I said before we went on the record, the motion for summary judgment is based on a failure to respond to requests for admission that were served on November the 25th, 2024. I believe the main basic focus of Mr. Johnson's response is that those were served. That was a second set of requests for admissions that were served after Mr. Buckler no longer had counsel, number one. Number two, I'll also note that the only reason we're having this hearing is because Mr. Johnson requested it. Mr. Hidari had filed his motion for summary judgment, did not request a hearing. Mr. Johnson, as he's allowed to do, filed a response and requested a hearing. And so that's why we're here on this matter. I will again note, as I did right before we went on the record, that the motion to dismiss, there is a motion to dismiss that's pending in the file. It doesn't make a lot of sense to the court in substantively, and certainly not procedurally as a proper motion to dismiss vehicle to challenge the pleadings. And so given that Mr. Johnson has not adopted it and is not urging it, I'm just going to enter an order that denies that motion. And so we'll just go ahead, Mr. Hidari, with your motion for summary judgment based on the failure to answer request for admission.
Thank you very much, Your Honor. I think you probably summarized my position more succinctly than I could, but it is a very simple complaint about damage to property, damage to realty. And so our request for admissions are predicated on the fact that the defendant has admitted that he damaged us either negligently or intentionally. He actually admits to both. And so those are our two substantive counts where we're moving for summary judgment. Now, as far as the defendant's request to withdraw admissions, I would be a little more sympathetic of the defendant's position if this was essentially the second time he's refused to participate in discovery. And so initially, Mr. Buckler was served with discovery along with the process server, and he filed some blanket denials for the request for admissions, but ignored everything else. If you recall, Mr. Buckler had predecessor counsel who appeared and essentially stated that because Mr. Buckler was not participating, he was going to withdraw. And that is exactly what happened. And so once he actually did withdraw, I turned around and served a second set of requests for admissions. I will note they are not identical. There are some similarities, there are some overlap, but I ensured that they were not identical, along with some other requests as well. And they were wholly ignored the second time around as well. And so that's the basis of our motion for summary judgment. I understand it. Mr. Johnson is probably going to move to withdraw, and I'll have some arguments as to why that's not proper, but that is essentially our position.
Understood. Thank you, Mr. Hidari. Mr. Johnson?
Sure. The summary judgment motion is predicated entirely on the second set of requests for admissions. And as I indicated in the motion to withdraw those admissions, there's no evidence that my client got them. He denies it. But there's also strong evidence that he didn't get them because there was this postal strike going on in Canada.
Yeah, that was very interesting to read that there was apparently a pretty large postal strike in Canada. So.
Right. And these requests for admissions were mailed to him in Canada while he was not represented by counsel. And so the time does overlap. And just so you know, we weren't scouring the internet trying to find some excuse. Mr. Buckler knew right away, if they served me this time, I would not have received them because nobody got any mail during that time. But in any event, putting that issue aside, the second requests are largely duplicative of the discovery he's responded to before, and they're duplicative of his denials in the answer. And we cite to a case, Brankovic versus Snyder, where the trial court allowed requests to be withdrawn and the Court of Appeals approved that on the basis that the discovery was duplicative and the admissions were duplicative of factual allegations that were denied in the answer. And in that case, the Court of Appeals found that there was good cause to withdraw the case or withdraw the admissions because that would allow justice to be served. That would allow the case to go forward on the merits. And I think we're on all fours here. He's denied this previously. His position is, I didn't do this damage. He's now responded to them. He never got them. And so he shouldn't be subject to a summary judgment motion based on something he didn't get.
Okay. Anything else, Mr. Johnson?
No, Your Honor.
Okay. Mr. Hidari, it's technically your motion for summary judgment, so you get to have the last word, sir.
Thank you, Your Honor. And this goes to Mr. Buckler's request to withdraw. So even if there was a postal strike, he's not saying that he responded untimely or whatnot. He's just saying he didn't respond whatsoever. And so these things were served back months and months and months ago. And so there was no excuse. It was, in fact, a tactical decision, I would say, considering he didn't respond to the first set of discovery that was served with the process server, which necessitated predecessor counsel's withdrawal. And he obviously knew the implications and timeline because he did file a pro se motion to dismiss within the time period as well. So that appears to be well calculated. Going to this request to withdraw, there's actually a two-prong analysis that has to be provided to withdraw admissions. And unless both prongs are satisfied, the admission should not be withdrawn. The first prong is whether or not there is evidence in the record that would basically subvert the admissions on their face and would be admissible in trial. And if only that's satisfied, do we get to the second prong, which is that there's no prejudice. As far as Mr. Buckler's affidavit withdrawing the motions or moving to withdraw the motions, moving to withdraw the admissions, they don't seem to identify any substantive basis to do so other than just a blanket denial saying I didn't do this. So I don't think it satisfies the first prong. But when we jump to the second prong, I think that's absolutely fatal, and that will obviate his request to withdraw the motions, to withdraw the admissions, which is the party who served him shouldn't be prejudiced. And I have a case on point that talks about this, and this is Marlowe versus Lott, 212 Georgia App 679, 1994. And so that's 212 Georgia App 679. And in that case, essentially, what happened to us happened there, which is the party that served a request for admissions did not pursue additional depositions, did not pursue additional discovery. And then the party that admitted things as a matter of law moved to withdraw, saying, well, I want to withdraw these. The court came back and said, no, that is prejudice. The time for depositions has lapsed. The time for additional discovery has lapsed. In our situation, we could have moved to strike their answer initially because they, again, didn't respond to any of the substantive discovery. We could have moved for orders compelling depositions, whatnot. In this situation, we didn't. Instead, we ended up filing our motion for summary judgment predicated on their failure to respond. And even though there is some overlap, there are a lot of different requests there, and there are a lot of different substantive admissions that Mr. Buckler made. And so this is the type of prejudice that was contemplated by the Marlowe court when the Court of Appeals came back and affirmed the denial of withdrawing the request for admissions. And so we would ask this court to do the exact same thing.
Thank you, Mr. Hidari. So let me say this. I don't love the way that Mr. Buckler has handled the obligations that he has to the court. I've seen lots of, I live in Canada, why are you even bothering me sort of things that Mr. Buckler has represented to the court over various times. Primarily when he was not represented by counsel, because thankfully when he is represented by counsel, he's represented by good counsel who knows how to handle these matters. But I will say this, at the end of the day, I think that Mr. Johnson is not wrong when he says that while it is frustrating that Mr. Buckler sort of chooses to participate when he wants to and doesn't participate when he doesn't want to, that at the end of the day, he does have counsel currently, and his counsel did the things that are necessary to demonstrate substantive responses having been made to the request for admission. I think for me, what is compelling is Mr. Hidari, although you are right that Mr. Buckler has minimally complied with his discovery obligations, and at least in one case only after discussion with the court. He did ultimately respond to the answer. He did ultimately respond to a prior set of requests for admission. But Mr. Johnson's point about the second set of requests for admission not being identical, I agree with you, they're not identical, but Mr. Johnson's point about the fact that they ask things that Mr. Buckler wouldn't necessarily have any way of knowing, like admit that the damages you caused to this property were exactly like $142,000 or whatever the exact dollar amount was. And I absolutely do not mean to imply that you did. I think Mr. Johnson goes further than I would, that you're trying to prey on an unrepresented individual, which I don't agree with. I think Mr. Buckler has made his bed in that regard. And ultimately, I do think that Mr. Buckler's attorney has done what needs to be done to justify withdrawing the deemed admissions, substituting those admissions for the substantive admissions that Mr. Johnson has filed, and that would defeat your request, your motion for summary judgment. And so for that reason, I'm going to deny the motion for summary judgment. I'm going to grant the motion to withdraw the deemed admissions. Mr. Johnson, can you submit a proposed order on those matters so that I can get something on file for y'all, and I will do something. I'll enter something on the motion to dismiss as well. Now, that leads, however, to our next issue, which is this case is long past supposed to have been set for trial. I think it was noticed for the month of March. It's April now. We don't have a summary judgment, but it also sounds like y'all don't have a whole lot of fulsome discovery. But those are the choices that Mr. Buckler made. So I guess my question is, my typical practice would be, okay, well, I've dealt with your dispositive motion. Discovery is concluded. You were supposed to be on the calendar in January, or excuse me, I'm sorry, March, and now we're in April, so May?
Your Honor, for Mr. Buckler, we're ready for trial. I think this is a 2-hour bench trial, so.
Mr. Hidari?
I think May sounds great, Your Honor, and we would appreciate that.
Okay, I will place you. So what will happen for the May calendar is you'll get a notice for a pretrial conference the first week of May. And then the trial week for me for May is May the 19th. So it will be some, and if it does go that week, now because you're not a jury trial, I can sort of fit it in wherever works for our calendars, including your calendars. And as long as y'all are okay with it, we can do the entire thing by Zoom instead of everybody having to come into the court. Okay.
Thank you, Your Honor.
Okay, excellent. You guys will be on the May trial calendar. You'll get a notice for a date certain for the pretrial conference, and we'll all take it from there. Okay.
Thank you very much.
Thank you. Have a good day.
You too.
Okay. I'm sorry, counsel for Brickell. Mr. Pugh.
Yes, Your Honor.
You're not who's listed on my calendar, and I realized I forgot to write down your name.
It might be Steve Yacklin.
Yeah, it is Steve Yacklin. Thank you.
Okay. That's my boss.
Mr. Pugh, Mr. Imzakwe has not appeared. No one has appeared on behalf of Boy Wonder. I know from your filing that that's not surprising. I suspect that Mr. Imzakwe failed to get further cooperation from his clients, and that's what has resulted here. As a result, all of my hearings are peremptory in nature, and if you don't appear, then your case is subject to all sorts of sanctions that the court might impose. In this particular instance, though, what I am going to do is I am going to I think what I'm going to do is continue. This case is still going to be set for the trial calendar on April the 29th. And I will figure out what that means for the motions regarding the service on the third party defendant. Is it Mr. Johnson?
Yes, Your Honor.
Okay.
Yes, Your Honor.
I understand there is a dispute as to whether service was proper. It's clear there's notice, but open question as to the service issue, and that your answer is, well, if nothing else, just let us serve him by publication. I'm aware of all that. But Mr. Imzakwe's absence and Boy Wonder's absence more particularly may result in the dismissal of the case, which is what all of my trial notices say. So I will take a look at that after the conclusion of today's hearing and let you know what action the court will take. But we're nearly an hour in from the designated time, and Mr. Imzakwe has not appeared, and so I do not expect that he will, particularly given the history of the case. And so I will be in touch with you regarding the steps that the court will take. But in the interim, unless I dismiss this matter, then what you can expect is that we will still be on the calendar for that April the 29th calendar for trial. And we will see if Boy Wonder appears then.
Yes, Your Honor. I appreciate it very much.
Thank you all. You may be excused. Have a good day.
Thank you. Thank you, Your Honor. Have a good day.
Okay, so for Mr. Pines and Miss Crowder, I am going to ask you, y'all probably already been multitasking. You can stay attached to the Zoom, you can log off, whichever you'd like, but realistically, I'm going to tell you that if you'll come back at noon, you will have my undivided attention, and that's realistically about how long I think it's going to take for me to get through the rest of these motions. If that works for y'all, you're welcome to stay attached to the Zoom. But if that's not going to work for y'all in terms of what you had scheduled for this morning, tell me that now.
I have 2 witnesses, Your Honor. I have no belief that there's any issue with that. As far as I know, they expected to have the day set aside. So,
Mr. Pines.
And as much as I'd like to watch your other hearings, I will log off and see you at noon.
Okay, excellent. If you guys will just log right back into this same Zoom at noon, then I will see you and we will take that matter up then. Okay.
Thank you, Your Honor.
thank you, Judge.
So,
Okay, now based on time announcements, this is the order we're going to go in. And for all of you lawyers who I'm not calling on immediately, as I said, you're free to sit here and be bored by other cases. You're free to, just turn your camera black and then rejoin at the appropriate time. I'm going to take up next the Kahinde. I'm sorry. No, I've already dealt with that one. I'm going to take up next the Bulbekian matter, and then it is almost 10. I expect I'll be done with that around 10:15, 10:20. I'm then going to transition to the Ironsides one, and then bringing up the end right behind that, probably closer to 11, will be the Galen Vick motions for summary judgment. Okay, so that's the order we're going to go in. If y'all all just stick around, we will try and get through these as quickly as we can.
Your Honor,
Yes, sir.
Ms. Gilroy,
Yes?
I'd like to share on the takedown if that's all right.
Oh, of course, yes.
That's
Okay.
all, Your Honor.
Thank you.
I'll share in too while we're at it, Your Honor. That'd be fine.
Okay, look at everybody getting along.
That's
Awesome.
right. That's right.
Okay. Madam Court Reporter, this is going to be a hearing on the Austin defendant's motion to dismiss in the case of Remy Bulbekian versus the estate of Richard Heyman and Michael and Lynn Austin, case number 25 CV 000473. I'll note for the record that this matter is taking place by Zoom and that counsel for all of the parties is present. Starting with counsel for the plaintiff, I'll ask for y'all to just make your announcements for the benefit of the court reporter. Mr. Perry, that's
David
you.
Perry for the plaintiff.
Monica Gilroy on behalf of defendants PJ Lynn Austin and Michael T. Austin.
Jordan Foreman on behalf of defendant, the estate of Richard P. Heyman.
Okay, thank you. So Ms. Gilroy, this is your motion. I'm going to start by telling you that I have read your briefing. And I'm going to let you present your motion and however you wish to. But I will say that I do have a couple of questions, not so much about your motion, but about the nature of I understand most of your motion is focused on the status of the Austins allegedly as bona fide purchasers for value without notice. But when I review it, when I look at these claims, what I keep stumbling across, and perhaps you wise folks who litigate these property matters all the time probably can educate me, but mutual mistake it's not really a claim as I understand it. Rather, it is a basis to rescind a contract. And if I'm wrong in that understanding, please educate me. But that's sort of what I'm struggling with. Can you sort of take it from there, Ms. Gilroy?
I can, Your Honor. Yes, and thank you so much. Off camera is my clients. They're with me as well. Yeah, that's sort of, you've hit it right on the head. That's why there's a failure to state a claim against my client, the Austin, right? This is a fight between plaintiff and the estate, right? Plaintiff thinks he bought one thing. Estate thinks they sold another thing. My clients are innocent parties to this whole thing. We do not have a dog in this fight. You are exactly correct. Mutual mistake is a theory under either reformation, breach of contract, but it would in no way apply to my clients, right? There was no mistake made on the part of my client. That's not what plaintiff is alleging. Plaintiff is alleging that at the time they went to contract with the estate, right, to purchase the property, that the four corners of the contract failed to include this lot that sits between the two parties' houses, right? So my clients, under the law, would not, none of those claims that plaintiff is making, they don't apply to us at all. The only thing they're seeking against our clients, which is patently unequitable and just absolutely against the laws of our state, is to try to strip my clients of title when they rightfully purchased this, Your Honor. They also did exactly what the textbook bona fide purchaser would do, which is, it's actually my case that came out at the end of last year. It talks about all the different ways you inquire to try to figure out what's going on with the piece of property.
Right, but forgive me for interrupting you, Ms. Gilroy, but
No,
so
yes, ma'am.
The reason I understand why you're arguing that your clients are bona fide purchasers for value without notice.
Sure.
Because if they were determined to be in that status, right, then theoretically there'd be no basis to equitably undo the title that they have to lot 51 and give it back to, or give it to, not back, give it either back to the estate or give it to Mr. Bulbekian because that's what he believes he purchased. So I understand that issue. Respectfully, I think that whether they are or are not bona fide purchasers for value without notice probably ends up being a fact question that turns on the nature and extent of what they knew or didn't know. But I guess my question is, however Mr. Perry frames the cause of action, if ultimately, even if you're right, which I initially suspect you might be, that the claims as framed currently are really directed at the estate.
Yes, ma'am.
If those claims are successful, then ultimately the Austins are going to be involved in this, because then there will be a dispute of if Mr. Bulbekian demonstrates that in fact the estate sold him lot 51, then the estate didn't have the authority to sell lot 51 to the Austins. And then we're stuck in this weird, will the court exercise its equity jurisdiction to undo those transactions? And so I guess I'm not asking you to tell the plaintiff how to do their job, but even if you're right that the Austins aren't maybe appropriate defendants for these causes of action, don't they eventually have to be involved in this in some way?
Not at all, Your Honor. And a couple of things, if I may. First of all, I don't think there's a fact question here at all. I think by virtue of the ability that we have to attach to the pleadings and to answers things that clearly show what the truth is, there is no question here that my clients did exactly what they were supposed to do. They checked the title was clear, the estate sold it to them. The estate never said, oh no, we sold that to Mr. Bulbekian. No, the estate sold it to them. So no, they don't need to be involved, Your Honor, because in cases like this, as I'm sure Your Honor has seen, right, there's still a cause of action with Mr. Perry against Mr. Foreman, right? Because Mr. Perry's going to say, no way, we paid either too little or too much, because we thought we were getting, too much, because we thought we were getting more than we were buying. The estate's going to be like, well, no, here's what we sold. They have a total breach of contract claim against each other, and going to the extreme remedy of stripping a third party who is, I think from the face of the pleadings, Your Honor, it is uncontested that we are bona fide purchasers. To go to that next step to try to strip us of our property, that just is not what I believe the laws are going to allow, nor there aren't any facts in dispute with the actual evidence. The evidence right now before you, Your Honor, is exactly what it's going to be. There is no debate or dispute here that at the end of the day, my clients, right, did exactly what a bona fide purchaser is supposed to do. They inquired. They had a dead tree. They went to Mr. Bulbickian's real estate attorney and or real estate agent and said, "Hey, you know, we got, if you own this lot, this is your dead tree." He was like, "No, that's not mine." Right? They then go to inquire, just like they're supposed to, into the deed records. Right? They do the highest and best thing that there was. Right? So no, at the end of the day, my clients should be nowhere near this. This is not their circus. Not, you know, nothing to do with them. And the inclusion of them is just legally incorrect and equitably just incredibly wrong, because we have a true fight, in my opinion, between the estate, the plaintiff, really even the real estate agents of both the estate and the plaintiff, but not with my folks. And we attempted to set this up for you in the confines of the 12v6 to show that there truly will never be a claim that they can make against us, because the equitable remedies, the equitable protections of bona fide purchaser will always be there, and there's nothing else they can point to. We weren't part of any contract. We didn't make any mistake. So I hope that answers your Honor's questions. I hear you, though, and it does make some sense in the thought of, okay, well, wait a minute. We're fighting over this piece of land. How do you not include the current title holders? But this is probably the picture textbook situation where the current owners have nothing to do with this. We are just people caught in the middle of this fight between the plaintiffs, and the law is not going to allow the stripping of their properties when they did everything that a bona fide purchaser is defined by our current Georgia law does. So we would ask that you grant this motion and take us out of this case, please.
Thank you, Ms. Gilroy. Mr. Perry.
Yes, ma'am. She's absolutely wrong. Bona fide purchaser for value without notice. In her own motion on page 3, she says, after the plaintiff purchased 100 River North Run Northwest, the Austins reach out to plaintiff's agent to ask if plaintiff would sell lot 51 to them since it was overrun with vines and underbrush, and were told, not in my lifetime.
Well, let me save you some trouble, Mr. Perry. I agree with you on that aspect of it, right? That I understand why Ms. Gilroy is asserting that her clients are bona fide purchasers for value without notice. But as I said a moment ago to Ms. Gilroy, and I still stand by that, I think that their status as bona fide purchasers for value without notice is likely a factual issue that is not appropriate to be adjudicated right now.
Yes,
my question, though, to you is whether or not this is a proper vehicle for Ms. Gilroy's clients to be present in this case.
Yes, ma'am, it is. We've got equity that's going to undo this mutual mistake. That's Long v. Walls, 226 Georgia 737 is right on point, even has a dead person in there. But it also says that where there's a mutual mistake, even if nor will be negligence of the party complaining to defeat his right of reformation. So not even my client's negligence would defeat his right of reformation. Now
but Mr. Perry, so here's what I'm struggling with, right? So first of all, as I said to Ms. Gilroy a moment ago, I'm assuming that when you say mutual mistake, what you mean is rescission, because that would be a basis.
Use the word reformation.
Or reformation, fine. But ultimately, that contract is between you or your client and the estate. The Austins aren't part of it. And if you were successful in demonstrating that there was a mutual mistake, the remedies would be either complete rescission of the contract or reformation of the contract, potentially as to the dollar amount. To Ms. Gilroy's point,
as to the land included.
Well, and that's what I was going to say.
The
To Ms. Gilroy's
would be
point,
protected were they not aware. Not only that, Mr. Austin is a real estate broker. He is very familiar with how real estate works and records. And he found out that the taxes hadn't been paid. He kept quiet, didn't notify Mr. Bolbekian.
I understand.
He then went behind Mr. Bolbekian's back.
Mr. Perry, that's okay. This is a unique case because we are at a motion to dismiss, right? And so normally we're not talking about all this stuff. Now, granted, we have a little leeway because the bulk of the facts that the parties would argue about have been attached to the complaint and therefore made part of the pleading. What I was going to say is the other possible way that the contract could be reformed if you were successful would be to clarify that it included lot 51, which, as I told Ms. Gilroy a moment ago, I think would somehow implicate the court's equitable interest. But here's what I'm struggling with. The two causes of action you have filed, one is a mutual mistake or reformation, right? And there's nothing for the court to reform relative to the Austins because there's no contract relative to the Austins, certainly not between Bolbekian and the Austins. And then the other cause of action is one for unjust enrichment, which I'm not sure is appropriate either, because a claim for unjust enrichment is where the party being sued has been granted a benefit by the party suing them that they're not entitled to receive or that they're unjustly retaining. And Mr. Bolbekian hasn't bestowed a benefit upon the Austins at all. What's happened is the estate has sold this property to the Austins. And so where I'm struggling, to be clear, I'm not saying I don't think you can assert a cause of action against the against the Austins. I'm just not sure that including them as defendants in a reformation of contract action when they're not a party to that contract, or an unjust enrichment contract when your client didn't bestow a benefit on them, is the right vehicle.
I believe it is, Your Honor. In order for equity to do its job in the first case against the estate, we've got to give him back the benefit of his bargain. He's got to get the land that he thought he was going to buy, the land that the estate thought they were selling, which their agent agreed she was selling the whole thing. The Exhibit D on my thing is a 3-page, 8.5 by 11 pamphlet that advertised some 3 acres sprawling across a 435-foot river frontage shoreline. The appraisal that was done by the law firm who represented the estate and provided to my client lists 2 tax parcel IDs, and it lists 2 parcels of land totaling what they advertised in their pamphlet. The pamphlet was done by Mr. Heyman before he died.
So, Mr. Perry, I've read the materials and I don't dispute that there's definitely
we can't undo the mutual mistake unless we involve the Austins. The Austins would be protected did they not have knowledge of Mr. Bolbekian's claim, which they admit in their own motion. They knew that he thought he owned it. And Mr. Austin, who is a real estate broker, knew that he was going behind his back. The tax bill never came to Mr. Bolbekian because it was inadvertently left off the deed. And then Ms. Gilroy just filed an amended answer where she admitted that the estate paid the tax bill on the lot when it came in. We never knew about it. Mr. Austin investigated, found out, didn't tell my client. He clearly knew my client had a claim on that lot, and he's not without notice. So what the law says and the cases say is that equity will protect a bona fide purchaser for value without notice. He had notice. And on a motion to dismiss, the allegations of the complaint disclose with certainty that the claimant would not be entitled to relief under any state of provable facts asserted in support thereof. I can prove he knew that Mr. Bolbekian had notice. And this is a fact case that a jury should decide, or the judge if it's a bench trial, the trier of fact. And a motion to dismiss is inappropriate at this time. We haven't even started discovery.
Okay.
Case was filed middle January. It was answered February. Motion to dismiss was filed shortly thereafter. We haven't really started on finding out what's going on in this case. And a motion to dismiss is wholly inappropriate.
Okay.
Your Honor, if I may.
Well, not yet, because I'm going to see if Mr. Foreman wants to add anything to the conversation. Mr. Foreman.
Yes, ma'am. I'm going to add more than I thought I would. You hear Mr. Perry speak about the listing agreement that was, first of all, prepared by a person that's supposed to be our agent, who apparently filed an affidavit on behalf of his client. And that, to be honest, remains a mystery to me. And I think we need to take a good hard look at whether we're going to try and take some action against our own agent, because that was wholly inappropriate. That being said, a listing agreement is just that. It's a listing agreement. There's a PSA, a purchase and sale agreement here, Your Honor.
Well, forgive me, Mr. Foreman, for interrupting you, but as I was trying to share with Mr. Perry, I understand all these facts are sort of in here because they were attached to the complaint.
Right.
And I've reviewed those documents and I don't, it's too preliminary for me to make any findings or anything, but it's clear to me that there's some kernel that Mr. Bulbekian was relying on, and that there's also some kernels that the Austins were relying on when they purchased this property, and the estate was relying on when it sold the property to the Austins. So I don't know that it benefits us to get down into the weeds, even though we could procedurally, because it's all part of the pleading.
I will respectfully disagree with part of what Your Honor just said, and that's this. And this is where I was headed. The purchase and sale agreement, not surprisingly, Your Honor, has an entireties clause in it. Okay. And that entireties clause says, it doesn't use the word listing agreement, but none of that other stuff matters. It's an agreement, and it says what it says, and it lists the property it lists. And by the way, for what it's worth, the appraisal that plaintiff has attached to its complaint shows a property is worth I believe it's $175 million, $1,175,000. The sale was for one lot for $1,010,000. That's a difference of $165,000, Your Honor. So I'm gonna, I guess, to just say it in plain English here, Your Honor, my client doesn't believe it made a mistake at all, and is very seriously considering filing its own dispositive motion, and maybe regrets not having done so already, because frankly, between the entireties clause and even if you look outside the contract, which you shouldn't by law, because that's what an entireties clause is. But even if you did, you're going to see that Mr. Perry's client signed a contract that only referred to one lot at a purchase price substantially below two lots. And of course, what Miss Gilroy attached, the extra exhibit, if you will, that she added yesterday, is an exhibit showing that when it was time to sell to the Heymans, my client paid the taxes. There's no mistake there, Your Honor. We knew that property hadn't been sold. And if I need to get an affidavit to that effect, I can do that as well. Maybe that turns into a motion for summary judgment. It's too late to do a motion to dismiss in the purest sense. But that's my client's position. I would obviously, I don't fully agree with either one of the other two attorneys here, but I would say my position is Ms. Gilroy's, but goes further, because we're going to contend we didn't make any mistake at all. In fact, we think that can be ruled on as a matter of law just by virtue of the contract itself.
Okay. Thank you, Mr.
Your Honor, just quickly, Your Honor, if I may.
Yeah, it's your motion, so I promise you're gonna get the last word, Ms. Gilroy.
Yes, ma'am. Thank you.
Okay, go ahead.
Okay, just two things. You hit it on the head, right? The current causes of action. I mean, this is a 12B6, right? There's a failure to state a claim in the confines of these pleadings. Okay, and you're exactly correct, Your Honor. What the plaintiff is alleging is not involving my clients. Okay, and if they were dismissed from this lawsuit, okay, and they continue to litigate with the estate, all right, and if in fact then if the estate did not prevail for some reason, then we'd have a different situation. But to include us at this juncture under the current way that it's pled it's just not appropriate. Forget bona fide purchaser for a minute. But you're right, Your Honor, the current way this is pled, there's a failure to state a claim, okay? The only thing I want to say about the bona fide purchaser is this is not, Your Honor, respectfully, a factual question. In the brief is cited WW3 Ventures. It's 370 Georgia App. That is a case that talks about when someone is a bona fide purchaser without notice, and it explains what notice is. So even if we take what Mr. Perry said on face value, that there had been some discussions or confusion post-plaintiff purchasing this lot, at the end of the day, when my client went to see, based upon what they thought, what was the status of the title, they go under this WW3 Ventures case because they have, as the law is now underlined, inquiry notice. They go to the #1 source. They go to the Holy Grail, right? They go to the deed record. And that WW3 case is going to say, it doesn't really matter what plaintiff thinks we thought, because that's what we're talking about. That's why this case fails to state a claim. It's all about what did my clients ultimately do? That's why they are bona fide purchasers without notice. Just because he may say something, when you go to the deed records and you see that there is title still in the estate, and the estate goes further, as Mr. Foreman says, that, you know, they didn't have a problem selling it to them, under WW3, that really turns that really tightens that concept of what does a bona fide purchaser without notice mean. So that's just the court. Thank you so much for reading everything, Judge, and for all your time. But I just would put that out in front of you for your consideration. Thank you.
Okay. Thank you,
Your
Ms.
Honor.
Gilroy. Yes, sir, Mr. Perry.
MPP Investments versus Cherokee Bank, 288 Georgia 558. The purpose of a bona fide purchaser doctrine is to protect the innocent purchaser from the true title holder who stands silently by and permits such purchaser to act on his own injury, who is guilty of laches and not sooner asserting a mere secret equity. He asserted his equity. Now, he was incorrect because of the mutual mistake that had occurred previously, and I think Mr. Austin kind of went behind his back and, using his knowledge as a real estate broker, saw that there was a mistake and chose to hide it and go approach the estate separately and get that property, even though he knew that it shouldn't still be in the estate. He knew that Mr. Bolbakian thought he had bought it. And the strict standard that is applied to a motion to dismiss, I don't think there's any way she can meet that, because under any state of provable facts, I think we got provable facts. There was a mutual mistake, and we got provable facts that the Austins were aware and were on notice of Mr. Bolbakian's claim.
Thank you, Mr. Perry.
Yes, ma'am.
Okay, so as I said from sort of the beginning, I did read the briefing. And as I said, although this is somewhat unique in the fact that there is a ton of information that's been attached to the motion to dismiss, or excuse me, to the complaint, therefore, you know, allowing the court to consider those things to the extent that the parties keep wanting to talk about them. I still am of the opinion that we should keep our evaluation at this early stage of the case more tighter. And here's what I think. I started with this, and so I'm going to end with it. I review, the first thing I do when I get, you know, a motion on a case is I go look at the complaint, and I ask, you know, I look at what is actually alleged. And in this case, there are 3 causes of action. There is a claim for mutual mistake, which isn't really a claim. It's really a claim for reformation based on a mutual mistake. But that necessarily requires that there be a contract that can be reformed. And while I disagree with Ms. Gilroy that the Austins aren't squarely implicated by all of this information and will necessarily at some point need to be involved in it because they own a piece of property that Mr. Bolbakian claims he rightly owns, however that gets resolved. But for today, I agree with Ms. Gilroy that Mr. Bolbakian cannot maintain a claim for rescission or mutual mistake on a contract that the Austins are not a party to. They didn't make any mistake because they're not a party to a contract that is allegedly based on a mistake. And then you guys have thrown a lot of case law at me, so I will throw case law right back at you, which is the Campbell versus Alien case, 338 Georgia App 382, which says that a claim for unjust enrichment will lie if there is no legal contract. But then it says the concept of unjust enrichment is premised upon the principle. Wait, hang on. I'm reading the wrong part. Here's the part I wanted to read. A claim for unjust enrichment exists where a plaintiff asserts that the defendant induced or encouraged the plaintiff to provide something of value to the defendant, that the plaintiff provided that benefit to the defendant with the expectation that the defendant would be responsible for the cost, and the defendant knew of the benefit being conferred. And there is no allegation, nor to to what I understand, Mr. Perry, to your point about the motion to dismiss standard, I cannot imagine a set of facts that could be proven by Mr. Bulbikian that he personally conferred a benefit upon the Austins. Now, so for all of that is a very long way of saying this. I'm going to grant Ms. Gilroy's motion to dismiss the Austins from this lawsuit. Now, that motion is without prejudice because I think there probably is a universe in which Mr. Perry can find the right vehicle to bring the Austins into the case, which by all rights ultimately may ultimately need to be litigated if the dispute with the estate ultimately ends in some relief in Mr. Bulbikian's favor relative to Lot 51. Now, that's an open question. And again, I don't question that there's probably a procedural vehicle that Mr. Perry could find. But I don't think that mutual mistake or unjust enrichment are the proper vehicles to assert causes of action against Mr. and Mrs. Austin when they are not parties to a contract and have not been conferred a benefit by Mr. Bulbikian. Certainly, Mr. Perry, they've been conferred a benefit probably, but legally it wasn't by Mr. Bulbikian. And so for that reason, Ms. Gilroy, I am going to grant your motion to dismiss. And if you could please draft a proposed order for me to that effect. To be clear, because this is being taken down, I do want to be clear. I am making no ruling on the issue that was asserted by the Austins regarding their status as bona fide purchasers for value because I don't need to reach it. And so I've made no finding, factual, legal, or otherwise regarding that issue and their status as such or lack of status as such.
Absolutely.
Your Honor, oh, sorry.
I was just going to say, anything else that the parties need from me on this matter, Mr. Foreman?
Yes, I was wondering if we could request that Ms. Gilroy add into this proposed order that, and I know it's stating the obvious, but that that thereby moots any cross claims that they have asserted against my client.
Well, they've been dismissed from the case. I assume Ms. Gilroy would be willing to add such a thing. Obviously, you're right, Mr. Foreman, to be cautious that it doesn't necessarily mean that those claims go away. Usually that's more with a counterclaim as a cross claim, but
I'm happy, Your Honor, to speak to Mr. George or Mr. Foreman. I don't think that's going to be an issue, but I need to speak to my clients because, again, my understanding of cross claims would be that certainly the counterclaim remains. But I'm happy to talk to Mr. Foreman. I'm sure we can reach a resolution, and I'll be sure to circulate the proposed order to all counsel, Your Honor.
okay. Anything else, Mr. Perry?
No, ma'am.
Okay. Ms. Gilroy, anything else?
No, Your Honor. Thank you so much. We appreciate all your time and attention and that of your staff attorney. You all are excellent. We appreciate your time.
Thank you. I appreciate that. Mr. Freehoff is excellent.
He is, yes.
Okay. Have a good day, everyone. For those of you who are left on the call, as I mentioned, am going to take up the Ironsides matter next. If you could give me about a 10-minute break, I need more coffee and I also need to go swear in 2 new baby lawyers because I'm the presiding judge today. And so if you'll give me, it's 10:23. I'll try and get back as close to 10:30, 10:35 as I can, and then we'll get started. Thank you all. Okay. I'm sorry for that delay. I got out there to swear in the new lawyer, and there was a search warrant that I needed to deal with as well. So thank you for your patience. Okay, Miss Houston, are you ready?
Yes, Your Honor.
Okay. This is going to be a hearing on a motion for sanctions in two cases. Ironside Homeowners Association versus Ironside East Atlanta, case number 2023 CV 379461. And also Ironside Homeowners Association versus Thrive Construction, case number 2023 CV 380296. I'll note for the record that this matter is being handled entirely by Zoom, that announcements for the court reporter, starting with counsel for the plaintiff.
Yes, good morning, Your Honor. Again, Chris Reading for Ironside Homeowners Association, Inc.
Okay.
Your Honor, Bernie Kistler for Thrive Construction and Thrive Homes, as well as Ironside East Atlanta LLC.
Okay. And I know we have other attorneys here observing, although they probably don't have a dog in the fight of the sanctions motion. Who do we have here on that?
Your Honor, Zachary Werfel here for Atlanta Metalworks Incorporated.
Okay.
Your Honor, Mary Margaret Noland for Exterior Traditions.
Okay.
Your Honor, Court Johnson for Drain Right, Gutters and Roofing, and Waterproof Decking.
And Rich Capriola also for the plaintiff. Mr. Reading will be handling the argument.
Okay, thank you.
Your Honor, Carter Bishop here on behalf of BFS Operations LLC.
Okay.
Your Honor, Miss Yingling, Marilyn Yingling here on behalf of Structurally Sound Georgia LLC.
Okay, excellent.
Your Honor, Emma Greer here on behalf of Correct House Rat.
Okay. Okay. I think that is everybody. And Mr. Reading, it is your motion. I will again start by saying I have read the briefing that's been filed. I, of course, remember prior discussions that we have had both informally and then an order that was entered regarding the status of discovery and the ability of the plaintiffs in the two cases to obtain what it felt was full and complete discovery from the Thrive defendants. And most particularly an issue associated with, and I don't remember the particulars of the name of the entity, but with the sale of certain either assets or contractual obligations that Mr. Kistler had asserted at various points on behalf of his client meant that they didn't have these documents or didn't have access to them. And so that's sort of the filter through which I'm telling you that's sort of what I believe I remember about this case and what I think I understand from having read the briefs. I do understand that your position in part as to sanctions is based on the fact that it was subsequently determined that the sale that Mr. Kistler had referred to excluded this property, and therefore there really shouldn't have been that issue. I think that's what I understand. So if anything I've said is wrong, please make sure to correct me. But if what I've said is correct, then please pick up from there and go forward. Mr. Reading.
There are a few items there in there to correct, Your Honor. The most recent, I think, statement from the court regarding the sale of the asset. I think, and I'll kind of just start there. The Mr. Kistler at various times, beginning with a discovery dispute conference, actually involving one of the defendants, Atlanta or Metal South and Gutter South, who have since been dismissed from the case because they had no involvement in the project, raised an issue concerning what documents that they had received. And during that conference was my first recollection of Mr. Kistler saying that the Ironside East Atlanta project was an asset that was sold in connection with the sale to Toll Brothers. And so that was the reason why they no longer had access to documents. In connection with that sale, Toll Brothers cut off their access to their server. It was unclear what happened to any physical files that may have been located. in Thrive Construction, Ironside, East Atlanta's offices. And that's consistent with a response to an interrogatory that they gave back in October of 2023. And I'll try to find it. It says Ironside East Atlanta LLC sold the asset to Toll Brothers. As such, it turned over all assets, including the requested files, to Toll Brothers. On information and belief, Ironside East Atlanta is making available the complete construction file for the material based upon the material provided to it. Again, this response was in an interrogatory given by Ironside East Atlanta in October of 2023, and was used to explain why the plaintiffs and other defendants had received such a limited document production from the Thrive defendants. And if I can just collectively refer to them as the Thrive defendants, that might be somewhat helpful. As it turns out, that wasn't accurate. And the Ironside East Atlanta project was not sold to Toll Brothers. In fact, it was an excluded asset under the asset purchase agreement. But nonetheless, that was still used as the explanation for why they didn't have documents. And I think as we go through, and I'll try to address the two main issues in our motion, I think I'll kind of walk through the issues of that the documents they purportedly delivered in November of 2023 were not the entire set of documents that the Thrive defendants had access to at that time, and that there's still some uncertainty as to whether a complete document production has been made by the Thrive defendants in this case, or in these cases.
Mr. Reading, let me ask you a question, because I know I've seen Mr. Kistler's written response a number of times that while you may still believe that there would be other documents, that I think Mr. Kistler's argument in part is that they've produced thousands of pages of documentation. It's not as if it's, there's nothing or there's 10 pages when there to be thousands. Why, in what manner, even if incomplete, in what manner is what's been produced insufficient, other than that you don't think it's complete? Is it that there's thousands and thousands and thousands more? Or is it that, why is what they've produced still insufficient, other than your position that it is not everything?
Well, Your Honor, there's a couple discrepancies that haven't really been addressed in Mr. Kistler's response. We have not seen the documents that were provided from Toll Brothers to Thrive, which I think Mr. Kistler is referring to as the reason why additional documents were produced in this case in May of 2024. Also, the response identifies certain file sizes for these documents that they had received from Toll Brothers, and those aren't consistent with the documents that plaintiff received from Toll Brothers. If the court recalls, we had to go actually subpoena records from Toll Brothers, which included complying with some fairly nuanced procedures in Pennsylvania, in order to try to get these documents. We also try to get documents from another non-party, in this case, a company called Ensign Restorations, that did some water testing or mold testing at the properties over various stages. It's our position that all those documents were always in possession of the Thrive defendants. And we've attached a copy of a series of communications back between, I believe it's October of 2021 and March of 2023, wherein personal counsel for Thrive, an attorney named Stephen Snow, was communicating with the Thrive defendants Toll Brothers, over a variety of different issues. One of which related to the Homeowners Association having made claims concerning water intrusion issues at the townhomes and saying, hey, we don't have any of our project files. Those were all taken by Toll in connection with when Toll Brothers bought Thrive, even though this was an excluded asset. So we're asking that you make those available to us. In a series of 2 communications in March of 2023, those documents were purportedly made available to Mr. Snow. Copied on those communications, at least the initial production, was Christopher Rudd, who's the principal for the Thrive defendants. Those documents, and again, I can show the court the communications if you would like, but those documents are redacted to remove the file link that was shared from Toll to Mr. Snow. So fast forward to November of 2023, when plaintiff receives 159 total files totaling 568 megabytes, and we have a fulsome production to the Thrive entities back in March of 2023. If I can just walk back a little bit, this is not limited to the Thrive defendants' failure to produce documents. The court entered an order on April 25th, 2024, in both of these cases, directing the Thrive defendants to, within 20 days, supplement their responses to interrogatories to provide full and complete responses, to verify those responses, and to, rather than invoking 91133C without identifying the documents that they're relying on to support the response, to actually identify those documents by Bates stamp. The Thrive defense have completely ignored that directive from the court. We have not received any supplemental responses to the interrogatories. We have not received verified responses, and although the response tries to explain why the documents weren't separately identified by Bates labeling, we obviously haven't received those specific identification of documents that are responsive to particular interrogatories. And the second issue that was addressed in the court's order is the production of documents. And again, still within 20 days, they were directed to produce all documents within their possession, custody or control, responsive to plaintiff's requests that were relevant to the subject matter of the litigation. So it's really two separate issues that they've not complied with. And as to the first of the issues, it's very straightforward. They have not done it. They have not attempted to comply with the court's order. Even after filing the motion for sanctions, we still have not seen any supplemental responses from the Thrive defense. I would agree with the court that the second issue is a bit more nuanced and in the form of what documents we have received, when we received them, and whether, again, the Thrive defense still should be sanctioned for their discovery of abuses. The November 2023 production was, again, kind of woefully lacking, and that caused plaintiff to seek documents from non-parties to try to get access to the project files for the construction of the townhomes. We also served a second set of requests for production of documents to the Thrive defense, requesting communications between Toll Brothers and Thrive. And those communications are what caused us to discover the communications between Toll Brothers and its litigation team and Mr. Snow back between October 21 and March of 2023, wherein these documents were purportedly produced. If the court would like, I can share my screen and kind of walk through those particular communications.
Please.
Give me 1 second. My apologies. So, Your Honor, this was attached to our motion for sanctions as Exhibit E, and I have some of these emails and communications bookmarked just for ease. But it begins with a email from Mr. Snow in October of 22 to an individual named Ben Gold, who is the litigation counsel for Toll Brothers. And it addresses the issues regarding the water intrusion issues of the townhomes. Part of what's been alleged in this complaint and the allegations that we were making at that time on behalf of the association, and that where he is requesting simply copy the entire East Atlanta project file into a Dropbox or share file link. And that's highlighted. It says this would avoid us repeatedly asking for additional documentation as the need arises. And on November 14th, All right, Your Honor, scroll through. These are chain emails, so it's I don't have that bookmark. So I'll just move forward to the March 21st, 2023 email that Mr. Snow is provided along with an individual, Christopher Rudd, which says, "Good morning, gentlemen. Below is a link to the requested files. Please, if you have any issues accessing the link." For whatever reason, this link is redacted from this document. But again, this is dated March 22nd, 2023, even before this lawsuit was filed. And Mr. Snow acknowledges receipt of the link. It says, "Will you please provide access to my assistant so she can access and download the docs?" And then there's a follow-up regarding Toll specifically providing its warranty records, that and additional information being redacted. And then we have an email again from a litigation paralegal with Toll Brothers to Mr. Snow, wherein additional documents are provided. Please let me know if you have any issues. And an email from Mr. Gold with Toll saying, "We have sent you all the invoices we have relating to the warranty work at Ironside, which with the subcontracts previously sent should be all the information, much of which Thrive should already have." And over various communications in this string, Mr. Snow acknowledges receipt of these documents. So there's certainly a fairly strong indication that all the documents regarding the Ironside East Atlanta project were produced to Thrive by Toll in March of 2023. And rather than produce them to us in November 2023, and again, I'm not suggesting Mr. Kistler necessarily had these documents, but it's certainly an indication that his client did. And Mr. Kistler in November of 2023 produces only just a few documents related to this project and explains to the court and in responses to discovery that he can't produce other documents because their access has been cut off. Well, these communications suggest otherwise. And again, this caused plaintiffs to incur a significant amount of expense on its own to try to recover these documents directly from Toll Brothers. And Your Honor, if I can also, so again, we ultimately did receive documents from Toll Brothers in this case. And I would like to, if I can, show you the kind of the file structure that we received from Toll Brothers in June of 2024.
Okay.
Hopefully that's visible. I'll try to zoom in a little bit. So these are, again, these were collected by accessing a link that I received from Toll Brothers, same way that a link was provided to Mr. Snow in March of 2023. I even checked the link yesterday and was able to access the link. These links are still active. I have it pulled up on my desktop if the court would like to see it in my web browser, or you can go through the folders that we received. So this shows again, the file structure and Mr. Kistler's identified.
Chris, if I may,
Yeah, you're not sharing your screen.
Oh, my apologies.
That's okay.
Are we?
It's thinking about it, but
Okay.
it'll get there eventually. Right now I'm looking at a black screen.
Here we go. I think now, can it be seen?
Yes, thank you.
Okay, great. Sorry, Your Honor.
No worries.
So this shows the file structure that we received from Toll Brothers in connection with our subpoena that was issued and domesticated in Pennsylvania. And ultimately, we had some negotiations with Toll Brothers on getting documents, and they made these documents available to us in communications with Toll Brothers. I did request, and that what they indicated to us is that we were receiving the documents that they had previously produced to Thrive. So within this production is a set of folders, most of them modified in March of 2023 by one of the individuals that's included on the communications with Thrive, with Mr. Snow on behalf of Thrive during this same period. And that actually sent him the link to the project files, or sent him the links to whatever's being produced from Toll to Thrive in March of 2023. Your Honor, I can click through these, and if you don't mind, I'll pull up the browser showing if the court can still see my screen.
I can.
I'll pull up the browser showing what's included within this production. And each folder identifying contracts will have a number of other subfolders. Again, a number of other subfolders, other documents. And I mean, I can go through all these. I'm not going to waste the court's time doing that, but there are a lot of documents that are produced.
And they appear substantive. I mean, at least in terms of the, like I just saw a spreadsheet that was, estimate or budget or something like that. So.
Well, correct. And then it includes survey plans specs. Here's a copy of the plans. Here's a copy of the CAD files for the plans, the PDFs for the plans. These are all things we did not get from Thrive Defense in November of 2023. And going back to these folders, there's different items in here. So if I look at the contracts, it'll identify 3 items contained within this folder. And if I go back to the browser, contracts, there'll be 3 items, and those items are separate folders, including, for example, consultant agreements. That includes 14 items of its own, and those all appear to be Word and PDF documents. So at least as it concerns the file structure that we receive from Toll Brothers, each of the items is identified as one item within that folder, whether it be a document or a folder of its own, which may have additional items or documents.
Okay.
Pull up another document, Your Honor. So again, we've downloaded all these documents from Toll Brothers, did that back when they were produced in June. And I went ahead and I think because Mr. Kistler in his response it was trying to explain that we're mistaken about when documents were received and whether we've received anything based upon kind of the properties of these folders and this production. I want to, if I can, I'd like to show the court the properties showing the size of the folder that we received in connection with the Toll Brothers response. And I've just screenshot that for the court to review. So this again is the Toll subpoena response from June 7th of 2024, a total size of 4.34 gigabytes, containing 3,741 files and 397 folders.
Okay. So, Mr. Reading, just to sort of, I mean, the reason I asked the question about the documents that were produced, right, is as you've just demonstrated and seem willing to concede, reasonably so, is that, yes, lots and lots of documents were produced eventually, and that you still have questions about the extent to which, I think I understand you to say, number one, the extent to which this is still not a complete production, and number two, that it was such a late production in the face of evidence that you've developed that indicates they had this available to them way back when and still were not providing it. Is that the sum? I'm sure I've downplayed it in a way that you would probably make it sound more egregious. And I don't mean to summarize it by summarizing it. I do not mean to imply that it's not egregious or unacceptable. But is that the sum and substance of your concern ultimately? That your client's position is that they had this all along and not only did not provide it, but affirmatively, best case, provided misinformation to their lawyer, who then reported it to the court, number one. And number two, still, even once those documents were produced, have not complied with the court's prior order by providing actually substantive supplemental or amended discovery responses.
Your Honor, I think that setting apart the characterization of it, I think that fairly summarizes the position we're taking in terms of the Thrive defendant's compliance with not only this court's prior order on discovery issues, but with just discovery under the Civil Practice Act and making documents available to the plaintiff, and again causing plaintiff to incur substantial expenses in trying to get these documents. And we're now nearly 2 years into these cases, and we're still having issues on whether they've provided documents to us. And I think the response only kind of highlights some of those concerns. And if I can go address some of those items, the response seems to characterize us, a plaintiff, as being mistaken over what documents were produced in 2023. Mr. Kiss, and I'll pull up the response because he pulls a copy of that file structure that we referred to, that was incorporated in our brief on page 18, and that I just showed the court, and characterizes those. So I'm not sharing my screen anymore. So if I go to page 2 of the response, the response indicates that the 2023 documents total 1,302. And I think what he's referring to is the 23 documents provided to Thrive. The documents provided to Thrive in 2023 total 1,302. And to demonstrate that, the response refers to the same file structure that we were looking at earlier that was produced to us from Toll Brothers. And instead of identifying these as items, it's identified as files. And there's a few problems here. One being they aren't files. These are items. Some of these are subfolders. And so whatever was produced in 2023, to the extent it's 1,000 pages as reflected on these 1,302 files in these folders identified above, that's inaccurate. The folders that we received from Thrive, which again, I can mirror these both, but contracts, we looked at that one specifically and clicked through. It says 3 files on the response. In the file structure, it identified those as 3 items. When we looked at that on the Toll Brothers website, or the document production website, it identified 3 items. And if I clicked through, I saw that those 3 items included folders, which each had individual files contained therein.
So, Mr. Reading, I think I have an understanding of what the alleged shortcomings were of the discovery.
Okay.
I think it would be helpful for me. You have the motion itself seeks essentially all available remedies up to and including dismissal, or I guess striking of the pleading, as well as attorney's fees. I'm looking at attorney's fees affidavits that have been submitted. Can you address that part of the issue in terms of why and to what extent, what remedy you're seeking and why the court should consider either or both the attorney's fees and the sanction of the striking of the pleading?
Yeah, certainly, Your Honor. If I could just address one other item as it concerns this file structure, because it does, it is one significant area of concern. And the response identifies folders that we did not receive from Thrive in 2024. So again, I can go back to the file structure that we had, but the 1,302 files identified in the response, of those files, 1,077 files are associated with open warranty, and we did not receive a copy of this file. I don't know to what extent we may have received portions of this file from the Thrive defendants. But one of the big issues in this case has been how repairs were made to the townhomes. And there appears to be a significant file that has been withheld from us by the Thrive defendants. I don't know where this information comes from, but it's very strange that the response identifies folders that are not included in the folders that we received from.
Well, giving the benefit of the doubt here, right? One might argue that that's an indication that the relevant files indicated there that their failure to be produced was inadvertence and not intentional, because if you're intentionally withholding documents, why would you acknowledge that they even exist?
I don't disagree that it would be, if you're intentionally withholding documents, it would be strange to kind of highlight them in a response. But at the same time, it doesn't obviate the fact that they have not produced them. And that one of the big issues in our case are, and I don't need to keep sharing my screen, but is what repairs were made. We've taken multiple subcontractor depositions in this case, and they've indicated, there were clearly some alterations done of the work that we did on portions of the townhomes where we've alleged, are the cause of some of the water intrusion issues that the townhomes are experiencing. And we don't have any documents from the Thrive defendants showing who was paid to make those repairs. We have parapet walls, we have flashing being removed and replaced. We have subcontractors saying, yeah, I did not install that. And those documents all could be contained within these open warranty folders, again, that have not been produced to us.
Mr. Reading, so I understand all that, but I guess the reason I've asked you to move along to the potential sanction that you're requesting is because I'm going to hear from Mr. Kistler about the circumstances that occasioned this, but I don't think there's really any dispute that you've not been provided with things that were requested that if they exist would be relevant, would likely be admissible. And so I guess I'm interested more in the extent to which you have been prejudiced in such a way that an award of attorney's fees and or a striking of the pleadings would be implicated here.
Yes, Your Honor. Well, again, the affidavits do identify, the affidavits that were submitted in respect to both cases, and they mirror each other, identify the time associated with plaintiff's efforts to obtain discovery from defendants in this case. That includes the requesting the discovery dispute conference with this court, ultimately obtaining the order requiring that they produce documents, and again, efforts to obtain documents from non-parties and the drafting of the sanctions motions that we're addressing today. To what extent
the dollar amount, I'm sorry, is $33,415.50.
That's correct.
And that is collective across both cases?
That's correct.
Okay.
And to what extent we've been now in this case for 2 years, and we're still trying to identify responsive documents from the Thrive defendants. We still don't know exactly the names of any other contractors or subcontractors that may have performed work on the townhomes, including most importantly the repair work that was done, that I think a lot of subcontractors will try to point to as there being alterations made to their work. So we have been prejudiced because parties have not been identified. And this goes back to the original discovery responses that the Thrive defense gave in this case, where instead of identifying the parties that did work on the townhomes, they referred to documents that they were producing in connection with discovery, which we didn't receive back in November of 2023. And now, which we've seen through these communications, are suggestive that these documents have been with Thrive since March of 2023. Okay. So there's certainly been significant prejudice suffered here.
Right. So, Mr. Reading, given the nature, so generally speaking, the remedy for a lack of discovery is discovery. And sometimes the remedy for a lack of discovery is you made us incur all this extra time and effort and money to obtain the discovery that we needed, and so you should have to pay our fees. And then sometimes the remedy, the argument is that the violations are so egregious that it rises to the level of striking a party's pleadings, which would therefore result in a finding of default. Why? I mean, case law refers to that as the sort of civil death penalty. Why is it that you think that these discovery violations are so egregious that the court should consider a striking of the Thrive defendants' pleadings in the two cases?
Yes, Ron. Well, I think we've addressed the law in part in our motion. I think we can certainly demonstrate that there's been willful noncompliance with this court's discovery order. Again, they did not address supplementation of the responses. They did not produce all documents, which they were directed to do. And they've acted in bad faith by repeatedly appearing before this court claiming we don't have these documents. And lo and behold, everything suggested that they did. And I can go through some of the other issues, and maybe I'll just address it once Mr. Kistler has an opportunity to address the court. Some of the issues with what they're claiming are some of the discrepancies between the documents that they received in 2024 and what may have been provided in 2023. But, and again, as I noted earlier, there's been prejudice suffered here, and that, again, we're 2 years into this case and we're still dealing with these issues. And secondly, there are other people other contractors or entities that may have performed work on the project that we still haven't been able to identify.
What is the status of this case in terms of its relative to where it is on its current amended scheduling order?
Well, the amended scheduling order that is currently in place has the discovery period ending at the end of last month.
Okay.
Now, we did submit revised, I believe it's the third amended scheduling order in this case, last week to Mr. Freehoff. That pushes that discovery deadline back to the middle of May. Pushes the mediation deadline to the end of May. It does not change the timetable for when this case appears on the trial calendar. I believe it's on schedule for in the August trial term.
Understood. Okay. Thank you, Mr. Reading. I'm going to hear from Mr. Kistler now, and then because it is your motion, you will get the last word. Okay. Mr. Reading?
Yes, Your Honor. Thank you.
Okay. Sorry. Thank you. Mr. Kistler.
Thank you, Your Honor. The police court. Obviously, I am representing the Thrive defendants, and I'd kind of like to address these issues in a reverse order. And the only reason I say that is I think it's easier to pick up with the supplementation. Understand that the documents that we received, which is 16,000, almost 17,000 documents, were done in response to this court's order, domesticating the subpoena and setting the terms of what was going to be produced. All of those documents have been produced. 16,500, almost 17,000 documents. We had a professional service receive those directly from Toll Brothers. We had those broken up into folders, PDF, I guess, folders of 500 pages each because it's too hard to open, obviously 17,000 page document. We had OCR put on it. I paid extra to have OCR put on it so that we could make these Boolean logic searches so that we could find the different documents that apply to any individual interrogatory or any specific request for production documents. Because again, reading 17,000 documents, when we thought it would be one thing, 17,000 documents, you can't just read it and go through it. So we tried to bust it up, try to put it in a useful format, and we provided that. I think that does comply with, I understand the 91133C argument, and that's what I'm going to there, which is go back and identify each of the individual documents. There's a bit of a problem with that, and there's a reason that I addressed it the way I did. Your Honor knows my client doesn't, and again, I'm using these terms loosely because I don't want somebody jumping on my knowledge of corporate structure, but none of our corporations exist anymore. The asset purchase agreement and the end of the Thrive companies, for lack of a better word, occurred in February of 2020. That was when Toll Brothers acquired everything. At that time, they acquired access to our offices, they acquired our servers, and yes, the documentation does show that my client was locked out. My client has nothing, literally nothing. Now, I did put a footnote. I want to address the footnote also. I think you probably saw the footnote, which is probably more interesting, which is in the abundance of caution, I tried to disclose that we thought there's a possibility of a flash drive existing that might have had the contents of the documents produced in March of 2023. Or that might have been documents produced made before the merger. I don't know what that is. That has never been found. That's never been disclosed, or not disclosed. It's never been discovered. I don't think it will ever turn up.
Right, but why does it? But why does it matter if Mr. Reading has just demonstrated to me that? I mean, maybe those companies don't exist anymore, but Mr. Snow still does, and his law firm still does, and he was provided with all those documents. So why does it matter if some mythical flash drive exists or doesn't exist?
Well, actually, that was the reason I wanted to get to that piece, because I think there's a fundamental misunderstanding of the Toll Brothers document or the Toll Brothers access that we just saw. And Chris, I was going to ask, since you have access to it, can you put that back up for us, where you can show us the current status of the what is it, the Dropbox or the share file or whatever it is? And
you can just tell me. It's okay.
That's not what was in it at the time. Everything that was in it at the time that was provided was given. And that's the original production. That's the original, I think somebody said it was 4,500 something pages.
Okay. Forgive me for interrupting, Mr. Kistler, but sort of in an effort to focus. I mean, as I said, whether it's because they don't exist or because nobody knows where they are, because your clients' corporate entities don't exist anymore, et cetera, I don't think there's really a whole lot of dispute that the universe of documents that did at one time very likely, almost certainly exist, are not available to be produced in this case, right? And that you have made some effort to produce what could be located or could be found. My question, I mean, this is a motion for sanctions, right? And so to me, the real issue, because I don't really think that the inadequacy of the responses and the production is in dispute. The question is, was it willful? And does it rise? Because as I said, the default generally is the answer to inadequate discovery is more discovery, or a prohibition on using other information or other documents at trial to support one's case. Sometimes if there are, willful failures to comply, it can be a sanction of, fees. And so the reason I say all that is I would like you to focus your attention on this. At least based on Mr. Reading's, my recollection of our discovery conference and Mr. Reading's characterization of the procedural history of this case, it does appear that your clients did not provide discovery until Mr. Reading and his client had gone to a great deal of trouble and expense to try and find it. And so what do you want me to know and understand about why that wasn't willful and why that doesn't rise to the level of some sort of sanction?
And I actually think there's a difference there in the completeness versus the word inadequacies. My understanding, not my understanding, but what we have is two different productions. I'm going to refer to it November 2023, and then he called it July. I actually received it May of 2024. I think that's when we got it. And then we referred all the stuff over to the service. Everything that I had and everything that was given to me, which is everything that we had gotten from Toll Brothers at that point, was produced. What was done, and that's a total of roughly 4,000 pages. Subsequently, when the subpoena was going on, and this board will remember, I was also trying to domesticate a subpoena for the exact same reason. I've said, I don't think Toll Brothers gave us all the documents. I don't think it's the complete file, but as you can remember, Toll Brothers and the Thrive entities were having a fight going back and forth. Chris put up one of the emails, and it was such a nasty fight at one point. They said we accused them of stealing our documents. And our reply to that wasn't, and it was not my reply, but the reply on behalf of Thrive was, no, we're not accusing you of stealing them. You're extorting them. You're holding them hostage and waiting to get some type of indemnity, unqualified indemnity promise in exchange for releasing our documents. I do not believe that there is any chance that what was produced by Toll in the original is complete. I'm not going to say it is. I don't think it was. And
right, but Mr.
Kistler,
what Mr. Reading has just shown me is that Thrive had access to it, despite the nastiness, despite the ongoing back and forth between Thrive and Toll Brothers, that Thrive had access to it at least back in March of 23, and it wasn't produced until much later than that, and then after a court order.
I don't think that that's what the share file shows, and that's wrong. I do see that those are dated 2023, but that's the date those files would have been created. That's not the date necessarily they were put in there. And the reason I asked to put it back up, there were also things dated 2018 and 2019. There were files at the very end that were dated 2018 and 2019. Clearly, they were not putting them in the Dropbox. Toll didn't even exist. Not Toll didn't exist. Toll had not acquired us at that point. Had not acquired the assets. Had not locked us out of our offices. Had not taken over and copied our servers in 2018 and 2019. I don't think the dates necessarily reflect the date that this stuff was produced, which is why I put the spreadsheet out there with the list of files and the list of names. You're absolutely right. If this was the smoking gun against me or against my client that they withheld documents, there's no way I would have put that out there. I mean, I'm dumb, but I'm not stupid. I would never in a million years have done that. And I guess that goes to the willfulness. Am I dumb but not stupid? But in all candor, all of those files were not in there. What we had was, I believe, a portion of those files. I believe they've since supplemented them or added stuff to them or moved more stuff into the Dropbox. And I can tell you, because I believe this document right here, there's actually stuff that's been taken out of that share file. So I don't think that's an accurate reflection of what it was. Even when Chris got into it, there's a folder called 01 Open Warranty. It's 2 gigabytes of data. It's not in there. It wasn't on the list today.
Let me stop you for a moment, Mr. Kistler. So, again, I don't think that there is a dispute as to the inadequacy or incompleteness of what was produced to, in this case, in the course of discovery. But even assuming that you know all that now and that you're able to explain all that to me now, part of Ironside Homeowners Association's complaint is that I entered an order requiring more fulsome discovery responses in which presumably the Thrive defendants would have been able to explain all of this, and that didn't happen either.
Your Honor, your order was asking me to have them bank stamped, which I did. We gave you a complete set of everything that Toll Brothers gave in response to the subpoena, which was a copy of everything, at least everything that they have produced. So once they did it again, they did a second production. It's our position there was a ton of stuff that was added to it. Now the question becomes, how can I then turn around with no entity and go back and mark each of the individual pages? And I started to do it. Then I thought about it and I was like, do I go back into every interrogatory what I did in 91133C? Do I go back in there and go, it's page this, page this, page this? When it's 17,000 pages of documents, that would have taken forever. I think it would have been more work for me doing, obviously, plaintiff's work at that point, trying to identify each individual document. When it's a smaller file or a medium-sized file, that's one thing. But once we realized it was 17,000 pages, the decision I made was, and it's what I put in my brief, I went and instead had somebody put the OCR on it so people could find responses themselves. Now, those documents, to be clear, have all been produced, 100%, and they are all stamped. They have all of the information on them. They have all of the information accessible. I don't sit here and profess to say that that is every single document that existed in the file, or that that's everything that was over there when Toll Brothers took over my clients. I can't say that. I can't certify that. I can't ask my client to certify. That's why the objections say what they do, which is, to the best of our knowledge, this is everything that we've got. And that's all that we can do. I don't know that there's any way that we can go back and certify or verify that it's everything, because we can't. So we gave all of the documents over. We made them available. We put them in a format that's easily usable by everybody. And again, had them bound in those individual volumes so that everybody could make access to them and everybody could get what they need. And the court will remember, I was actually domesticating my own subpoena at the same time against Toll Brothers because I didn't think we had everything. That was what I was doing. I was doing a parallel thing. We were sending, I think you can see in my thing, where we actually sent a courier because I wanted to document and a receipt proving it wasn't just my office calling going, hey, what's going on? Can we get a subpoena? And that was during the time of the hack, when the courthouse was hacked. So I mean, we had somebody go down there 2 different trips, I believe, to try and get a subpoena before it. I don't want the documents. I need them. It's not some kind of willful intention for us to withhold them. Heck, they hurt me more than they hurt anybody else. And the absence of these documents hurt me because, as you know, any stuff that's out there that's not in this case, I can't tender to them. Any stuff that's out there is not going to be paying their portion. So guess what? Coordination of benefits guy gets stuck with that. Coordination of trades, which is the general contractor's responsibility, gets those. We want those. I think if you look at the emails, obviously Chris did a great job of putting them in there. You see how hard we were fighting to try and get the stuff. I don't believe, and I just have to tell you, I don't believe that everything that's showing up in there now was given to us. It was given to my client in 2023. I really don't. I don't think the architecture matches. I don't think the files match. And that's the reason I put that information out there, so that you could see that it doesn't match. We wish it had been everything. We would love to have had been everything, because there would have been other subs brought in here and other trades that potentially could be involved. I don't know if we're missing any meaningful subs, but we run the risk that if there are meaningful subs, if there's a framing contractor who's not in the case because we didn't have those records, so we couldn't identify the framing contractor and they couldn't bring them in as a defendant. I eat that. That's not something you do willfully. You don't willfully withhold documents to hurt your own case. That's it, going to the willfulness. It's just not. I mean, again, I can't say that. I can't say that more clearly. Maybe there's a better way to say it, but there's nothing willful there, and quite frankly, it's like shooting myself in the foot.
Okay, thank you, Mr. Kistler. So, Mr. Reading, I will let you have the last word, sir. It's your motion.
I'll just make a couple points, Your Honor. What Mr. Kistler is suggesting is that by not identifying potential other parties that did work at the time, his client may be prejudiced. Well, that doesn't excuse us from also being prejudiced. And the indication is that the documents that they got are in response to the subpoena that we propounded on Toll. And I'll remind the court, we didn't get documents from Toll Brothers until June of 2024. In the response, I highlighted a section on page 8. There's an indication that Toll Brothers produced a share file to Thrive's personal counsel, again, Mr. Snow, who I assume that's in reference to, on April 19th of 2024, which was before we had ever received any documents from Toll Brothers. And again, there's some things here that just don't make sense. It says, unlike March of 2023, when there were 944 Ironside files, there's no explanation for where those 944 files, what that's in reference to. I'll note that we only received 159 files in the November production. The share file contained nearly 9,172 files and nearly 12 gigabytes of data. Well, that's not consistent with the file size, the number of files and the file size of the documents that we received from Toll Brothers. And, you know, I'll take Mr. Kistler at his word that he's produced the documents that have been given to him. But it's pretty clear from these communications that they were previously given to Thrive. And that's the issue that we have. And I'll again just jump to Exhibit A and B to the response. Again, this is Mr. Kistler and the response showing the size of the folders received from Toll Brothers. And the title of these files are Ironside Files 323-2023, which is consistent with when the first share file link was sent to Thrive's personal counsel. If I go to Exhibit B, it's dated 3/31/2023, and it's a smaller size, but that's the exact date that the second share file link was sent from Toll Brothers to Thrive. So I don't think an explanation has been provided by Mr. Kistler as to the disparity between the March of 2023 production and what may have been received then. But these emails certainly, and these folders that he shared in his response certainly seem to indicate that are completely coincide with the communications between Mr. Snow and Toll back in 2023.
Thank you, Mr. Reading. Can you take down your screen share, please?
I will, Your Honor.
Your Honor, may I have 1 second to address those, because those actually were fantastic.
Yes.
Those actually show that they are from April of 2024, that somebody named their folder, and that's the reason I produced that. If you look at those two exhibits there, those are created April 2024. They say that they are files of March 2023. Was it March 23, 2023 and March 30 or 31 of 2023? But if Crystal put those back up, you can see those folders were actually created April of 2024. I want to be clear. So that's exactly what I think has happened here. Is Toll Brothers produced some documents the first time. We produced what they gave. That metadata that I just showed, or whatever that is, that little screenshot, was to show that they used the same name for the files, but they created new folders in April of 2024 and put the 17,000 pages worth of documents in there. That's actually there to show that what was provided to us was not the same thing as what was provided in response to the subpoena. If that makes any sense. I just didn't want the court to think that because those folders are named March 2023, that means that that's what was in it in March of 2023. Because when I put there that 10.5 gigabytes or whatever, I thought it was 12 gigabytes. For some reason, I thought it was 12 gigabytes. And maybe that's a typo, but I think it said 10.49 gigabytes when you put that back up there. That's what was in it in April of 2024 when they produced it, not what was produced in March of 2023. So I just wanted to apologize for jumping in. I know he was supposed to get the last word, and I'll shut up and let him have the last word on it, but
Okay.
I thought that was important to point out.
Thank you, Mr. Kistler. So I definitely don't pretend to be particularly fluent with some of the technology. The last time I had to make electronic discovery was 8 years ago. And the technology wasn't as good as it is now. And so, if you're representing to me that there's some, document file somewhere that people are still somehow loading things into that changes what was produced, then I would submit to everyone that there needs, given the obligation that we all have to be able to account for what we have and when we had it, feels like there's probably a way to solve that problem. And that this might be an excellent example of why one ought to be able to account for what existed when and when it was provided and in what medium. Having said all that, I think I've made two things clear. One is, I don't think there's any dispute that the Thrive defendants did not make discovery in a timely fashion. We had a discovery conference. I entered an order. And while the Thrive defendants made some effort by filing on May the 15th additional documents, and Mr. Kistler, your point about not having to go through and find every single document and respond in that way, it's a fair point, but it also sort of ignores the specific direction that was provided by the court in the order. But having said all of that, I've not heard anything that would imply that Mr. Kistler was actively willfully defying the court order, except to the extent that he didn't cross every T and dot every I relative to the compliance with the order. At the end of the day, he, I believe, attempted to exercise good faith by complying with the order, with the spirit of the order, which was to find additional documents and produce them. Now, Mr. Kistler's good faith does not extend to his clients. And I know that's unfair, Mr. Kistler, because your clients may or may not exist, and whoever those principals are and that sort of thing. But at the end of the day, I don't think there's really any, I do not have any doubt that Ironside, East Atlanta, and Thrive Construction and Thrive Homes, LLC, who I believe we have been collectively referring to as the Thrive defendants, have failed to fully and completely satisfy their discovery obligations by producing responsive documents, by identifying responsive documents that exist but that are not being produced. And as a result, I think that that some action by the court is appropriate. However, I also think I've made clear that, there's a reason that striking somebody's pleading is disfavored under the law, and there's a reason that the case law very clearly supports that the answer for incomplete discovery is more discovery. So it seems that there's been some effort to provide more discovery. And so I will say, let me say this. I am not going to strike the Thrive defendants' pleadings at this stage. I am, however, going to order that the Thrive defendants are jointly and severally sanctioned in the amount of $33,415.50 under 9/11/37. Beyond that, what I will say is that, and I say this at pretrial conferences anyway, but if an objection is made regarding those documents weren't produced in discovery, then you need to be able to demonstrate to me where they were requested in discovery. But assuming that it was, that's what's going to happen, then I'm just going to, blanketly advise the parties that, as often happens when one is preparing for trial, one finds documents from their own client that help their case, and then they realize that those documents weren't produced in discovery. And so I just want to be clear that my ruling is going to be that nothing that was not produced in discovery up to this point, if in fact it was responsive to a request that was made, and let's face it, Ironside Homeowners Association's requests were pretty broad, so it will probably be pretty easy for them to demonstrate that such documents would have been responsive to a request and or implicated by the court's prior discovery order requiring production. What I do want to be clear about, as I started with, is I'm not sanctioning Mr. Kistler, and I'm not including him in that sanction, nor requiring that he be financially responsible for the attorney's fees sanction that I have just imposed. At this point, I am not going to strike the pleading of the Thrive defendants, but I reserve the right to do so if it later is demonstrated to me that, in fact, there are additional documents, whether found through a third party or otherwise, that would be outcome determinative or informative in terms of outcome determinative is too strong, I'm sorry, but that would be informative, would be likely to lead to the discovery of admissible evidence regarding other contractors, regarding warranty work that was done on the property, which are the general categories I've heard Mr. Reading characterize as necessary information that they're still not sure they have the answer to. That's going to be my ruling. Mr. Reading, can you please provide me with an order that, a draft order that does that? And I know you both have questions, which I'm about to ask. Mr. Kistler, do you have questions? Anything else you would like to address regarding the ruling that the court is making?
Two incredibly short things. First of all, I'm sitting in the back of my car, my air conditioner turned off, and I'm starting to sweat. So I promise that it's not nervousness. Although
I have attended hearings from stranger places as well, Mr. Kistler. Go ahead.
So but the car shut off. So that's what that is. The only thing I was going to ask, and maybe Chris and Rich can chime in on this. One of the defendants actually filed a special appearance answer. I think it's unanimous that it has no bearing on this case. Not that it matters. It doesn't change anything. But literally, the Thrive Homes had nothing to do with this project. It actually owned a separate piece of dirt. I think they were picked up because the meeting showed up. So I think it was thought that I don't know, Chris, if we can have a conversation about whether Thrive Homes should or should not be covered under that. Or not that it matters, it has no assets. It was the first one to shut down. But it shut down and went out of business even before the Toll Brothers transaction occurred and before, I believe, Ironside started.
So that, Mr. Kistler, you may be right, and that sounds to me like a conversation that you and Mr. Reading should perhaps have offline. And if Mr. Reading is in agreement with you based on the information that y'all have available, he may be willing to forego including that particular defendant in the sanction order that I've just entered, that he's going to provide me with a proposed draft of. Or some subsequent agreement to dismiss that entity. But that's a discussion and decision that y'all will need to make fairly soon so that that proposed order can get to me. Anything else, Mr. Kistler?
That's all I had. If you got an order and it had one of the names off, I wanted it to be understood why that possibly could be the case. So
thank you. Mr. Reading, anything else?
No, I can certainly discuss that offline with Mr. Kistler. I don't have anything else to add. I mean, it might be somewhat helpful to get some clarification from the court on the on the third amended scheduling orders that the parties submit in this case, just to
Yeah,
make-
when
know-
you
I
said
know
that,
not-
I was looking at my email. I haven't seen it come through my email. I don't have any concern about granting it. I did have a question though, just generally in terms of scheduling. So you can expect that scheduling order will be signed soon, probably today. I did want to throw out there, I don't think anybody needs to answer just yet what their position is, but I'm sure you're all aware that Garcia defendant, the third party defendant Garcia has filed, is pursuing appellate review of my denial of their motion for summary judgment as to the third party claim with structurally sound. I don't know if the court will grant, the Court of Appeals will grant that interlocutory review. But if they do, as I sit here now, I'm of the opinion that that doesn't stop this train from continuing to move. But if the parties have a different opinion about that, y'all can let me know. But I do want to let y'all know that issue because in 40 days, we'll know if the court is going to accept interlocutory review of that particular third party claim and the summary judgment denial that went with it. I wanted to mention that so that if you don't agree with the court, and it does end up happening that the Court of Appeals accepts review of that claim, y'all need to let me know what the parties' positions are about the extent to which these cases can and should continue, given that the underlying claim that would be reviewed by the Court of Appeals is in fact a derivative claim based on indemnity. So in any event, that's just my thought process, and I wanted you guys to be aware of it, because if you disagree with me, you can tell me why you disagree, and then maybe you'll convince me, and we will all take a break while the Court of Appeals figures out what it's doing. But we may not have to cross that bridge, because it may be that Court of Appeals declines to accept the invitation for interlocutory review. Okay?
Yes, Your Honor, thank you. I think that is something that we do intend to review and address with the court in the event that interlocutory appeal is granted, and we'll certainly give an opinion to the contrary if
Okay.
the matter should be stayed.
Okay, excellent.
Thank
Thank
you,
you all very much for your time, and I will look for your order, Mr. Reading.
Yes, thank you, Your Honor.
Thank
Your
you.
Honor. May I
Yes.
just inquire very quickly, Mr. Kessler, are you participating in takedown with Mr. Reading?
Yes, I am so sorry. Yes, absolutely.
And I have an email drafted if anyone wants to order a transcript. I've got all the parties present. I'm going to send it to you guys as soon as I log off here. As far as orders, if you guys ever want to order a transcript.
Great. Thank you, Ms. Houston. Thank you for being here.
Thank you.
Thank you.
Okay. I am about to take up Vic versus Reverse Logistics, but I have a search warrant that I need to address real briefly. So if you guys can give me about 5 minutes, I'll be right back with you. Okay. Mr. Strauss and Mr. Knowles and Ms. Davies. Okay, Mr. Knowles, who am I going to hear from regarding your matter?
I'll be making the argument for the defendants.
Okay.
Ready to go?
Yes, sir. Hang on. Do you have a court reporter? I forgot. You do. Ms. Johnson, are you on?
Yes, ma'am, I am.
Okay. Ms. Johnson, we're ready to go on the record. This is going to be a hearing on motions for summary judgment in the matter of Galen Vick and Stella Vick versus Reverse Logistics Trends et al. Case number 24CV002057. I will note for the record that this matter is taking place entirely by video. Mr. Knowles and Ms. Davies are here on behalf of the defendants who have moved for summary judgment. Mr. Strauss is here on behalf of the plaintiff who is opposing those grants. Mr. Knowles, please go ahead.
Thank you, Your Honor. And before I get started, does the court have any questions after reading the brief that I can make sure I answer my presentation?
Well, I mean, mostly, no, it's very straightforward. I think that what would be helpful, and I feel like you've done this for me before, is to give me a little bit of a flow chart for the various corporate entities and their relationship, because obviously one of your, at least regarding reverse logistics, is that there can't be tortious interference claims against some of these entities because they're not strangers to the transaction. And then it also seems like primarily your primary argument is the contract required a payment based on revenue, and if there's no revenue. And so I guess my question is, it would be helpful to the court for you to point directly to how there is not a dispute of fact as to whether there was or was not revenue, and how much revenue there was, if there was revenue, why that's not a disputed fact in the context of this motion for summary judgment.
Okay, yes, Your Honor. I have a chart. It's not a flow chart. Ms. Davies did remind me that we had one last time, so maybe she can dig that up while I'm talking. So the plaintiffs here, their complaint really is attempting to spin what should be a simple breach of contract claim at best into something much more dramatic and completely unfounded. The two overarching undisputed material facts that are above all of our arguments may I share my screen, Your Honor?
Yes.
Oh, I'm messing this up. Are that the plaintiffs entered into this stock purchase agreement, the highlighting is mine, with Reverse It Sales and Consulting LLC. The party, and the second critical material fact that's undisputed is that the plaintiffs entered into this personal independent consultant agreement with Reverse Logistics Trends. So again, I don't want to belabor this because I think it is a simple point, but in the stock purchase agreement, the entity that is the party is Reverse It Sales, and Reverse Logistics Trends is mentioned in there, but it's the company that's subject, that its stock is being transferred.
Mm-hmm.
And then that company is the party in the personal independent consulting agreement. And again, I know you probably got that, Your Honor, but there's been some question about whether, both of these entities owe money under both agreements somehow. And so I want to be clear that these are two contracts with two different parties. And also both of these documents, to the extent that plaintiffs have asserted that there are, there's like some, over global verbal agreement that ties all these together. Both of these agreements have a merger clause, which is paragraph 20 in the stock purchase agreement, and a no unwritten amendment clause, which is number 17 in the stock purchase agreement. Those are also in, or similar provisions are also in the independent contractor agreement at 12C and D. No merger clause and no unwritten amendments. And while I have these up, I just do want to mention that the stock purchase agreement does say on page 2 under section 4 that the purchase, I think it's supposed to be purchaser, which is reverse it, will cause the company to enter, the company, which is RLT, to enter into the consultant agreement with sellers. So that is an obligation on reverse it, who is buying RLT, that once they've completed that purchase, they will then, as the owner of RLT, cause RLT to enter into the independent consulting agreement. But that's it. It doesn't say that reverse it is guaranteeing that obligation. It's just that it's going to cause RLT to enter into it. Finally, Your Honor, I'm sure you're aware from reading the brief, the purchase price for the shares in the stock purchase agreement was 0.5% of the monthly gross revenue of RLT, even though RLT is not a party to that. The purchase price is tied to RLT's revenue, and that purchase price is a total of $120,000. And then under the independent contractor agreement, the compensation is 4.5% of RLT's own monthly gross revenue. So in our briefs, we had some background facts, and I'm always worried I'm going to annoy the court with those, but because they're not relevant for summary judgment, they might be better described as noise in the brief.
Well, it is helpful to provide that lay of the land in terms of how everybody got where everybody is and what the background is. But I have the benefit not only of your brief, but of having had some motion practice in this matter before in terms of having gotten a little bit of a background from you. So I think we can probably dispense with that, except to the extent that you think it's particularly relevant to some issue on summary judgment.
Your Honor, I appreciate that, and to give a very high-level overview, the plaintiffs are, each parties have their own noise. The plaintiffs are saying, painting this picture of a thriving company that was stolen by the defendants. We strenuously dispute that assertion. Mr. Vick did, build the company from 2022 to 2009, but based on some issues that he had that we've gone over in our brief, from 2009 to 2016, the RLT declined precipitously, and reverse it essentially bailed it out in 2016. Based on, we've asserted, some fraudulent representations were made to reverse it.
Right, I understand that, Mr. Knowles. Forgive me for interrupting, but so when I hear things like we dispute that and blah, 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 right? We're here on summary judgment. Your point is not that if we go to trial, I'm going to hear all about how the parties disagree about everything. Your point on summary judgment is everybody agrees on this, or the plaintiff didn't come forward with any evidence to create a dispute about X. And so let's stick with that, because clearly I understand the parties disagree about the value of the company and the circumstances that led to its purchase and all that stuff.
Absolutely, Your Honor. And I was finishing up with my noise part of my presentation and moving on to the the actual material undisputed facts here, which are pretty limited and straightforward. In my opinion, in our brief, those sections are pretty short in our brief. If I may share my screen again, just putting these up here visually, there's 5 undisputed facts that if the court recognizes that they're undisputed, and I don't think plaintiffs can dispute these, that it will decide the motions for summary judgment and defendant's favor. The first one is that the stock purchase agreement and the consulting agreement are binding and have 2 different parties. Both contracts, as I said, have these merger clauses and written amendment clauses. Neither contract says that RLT cannot transfer assets, and reverse it paid off a $122,000 debt to the Rio Hotel in 2016, and 5, that Rio debt was an indemnified debt under 6G, Schedule 6G of the stock purchase agreement, which I will go into that a little bit more in just a moment. And so, yeah, actually, I'll go into it right now. Sorry, I was skipping around a little bit because I didn't want to belabor any points. So if I may pull up the stock purchase agreement, Your Honor, I just want to show you what I'm talking about here, in case you haven't looked at it. But this is the stock purchase agreement. And in the stock purchase agreement, there in section 14, there's an indemnification provision where it says the seller, jointly and severally, which is the plaintiffs, agrees that they will indemnify, defend, hold harmless purchaser, which is reverse it, from and against, and in any respect, losses asserted against and imposed on or sustained, incurred, or suffered by purchaser, which is reverse it, in any such case to the extent arising out of, it lists several things. I'm going to skip down to little Roman numeral 4, the litigation and claims set forth as of closing, including but not limited to the matters disclosed on Schedule 6G hereof. And 6G is illegible to some degree. We talked about in the deposition, everybody agrees, and I ham-fistedly put a little, inserted this into the document just so the court can see it. This part in red here is not actually part of the stock purchase agreement, but the yellow highlighting turned gray in the final signed agreement, and Mr. Strauss and I have not been able to locate a final document where the highlighting is yellow. So I'm just putting this here from a draft version, and I don't think Mr. Strauss will contest that. But on Schedule 6G, it has Rio Hotel, $122,000, and it's undisputed that on July 28, 2016, shortly after the purchase, Reverse It Sales paid this $122,000 debt to Allied Collection Services, which is the debt collector for the Rio Hotel, as mentioned in the 4 column of the check there. As I said, Your Honor, nothing in either of these agreements precludes the sale of assets. Plaintiffs have cited to Section 16 in the stock purchase agreement. I'd like to pull that up. Sorry, I'm screen sharing so much, Your Honor.
No, I appreciate it. It's helpful to see the documents.
Okay, good. I was hoping that didn't annoy you. So the assignment clause says, I want to read this, no party to this agreement, again, this is the stock purchase agreement, so the parties are the plaintiffs and Reverse It, who is buying RLT from the plaintiffs. So in that agreement between Reverse It and plaintiffs, it says no party to this agreement may assign any of its rights or obligations hereunder without the prior written consent of the other parties. Here too, which consent may be withheld in the sole discretion of the party from whom consent is sought. The plaintiffs have read intellectual property into this provision here, but nothing in the stock purchase agreement says anything about, rights and obligations related to IP. The only references to intellectual property that I've been able to find are here in section 6P, which is the representations and warranties of the plaintiffs. And they're basically representing to the purchaser that RLT, the company being purchased, has all the IP it needs to have to function. It's a pretty standard thing in a sale of business contract for the seller to represent and warrant, I haven't already sold the IP. So you're not going to buy this company and then turn around and realize you don't have all the IP you need to function. And same thing over here in Section 8B. It's a post-closing covenant of the plaintiffs, the seller, that they will cooperate to make sure that the company IP is available to RLT for 12 months. So if something happens and the buyer has a problem with the IP, RLT has a problem with the IP, then the sellers will come in and help RLT figure out why they're not, what the issue is with the IP, basically a cooperation clause. But going back to Section 16, which talks about rights and obligations, the rights and obligations in the stock purchase agreement are stock and money. The plaintiffs have the right to receive the money, and Reverse It has the right to receive the stock. Reverse It has the obligation to pay money. Plaintiffs have the obligation to turn over the stock. So there's no, the plaintiffs have tried to paint that section as if there's an IP obligation in the stock purchase agreement, and that therefore when RLT, who is not a party to the stock purchase agreement, transferred its assets to NRF, that was somehow a violation of the stock purchase agreement, when the stock purchase agreement doesn't say anything about rights and obligations related to IP.
Okay.
I noticed you looking there, Your Honor. If you have any questions about that, let me know. I know that's
I have
on.
The documents and Westlaw open over here, and so that's what I'm looking at is when you're doing that. Okay. So, okay.
And just look at make sure I don't miss anything. So as I mentioned earlier, Your Honor, I apologize for all the briefs here. It was actually more confusing to try and squeeze it all into one brief, if you can believe that. And I pulled this up earlier. Step my sorry, I messed up my PDFs here. Let me fix this. Okay, if I can pull this back up. I made as I mentioned, I do have a chart, not a flow chart, but I made this chart of the parties and the claims, the substantive claims. Count 4 is attorney's fees, so I didn't put that on there. And I also didn't put Reverse Logistics Association, Inc. on there. I believe the parties are in agreement that RLA Inc. can be dismissed. And as we mentioned in our brief, there's a distinction between this RLA Inc., which was basically just a company that nobody ever did anything with, and the RLA trade name, which was an asset of Reverse Logistics Association, or Reverse Logistics Trends. So my reading of the summary judgment brief filed by plaintiffs, and Mr. Strauss could correct me when he speaks, and I'll address it in rebuttal with the court's permission if this is incorrect. But my understanding, based on the briefing, is that the claims plaintiffs are now asserting against RLT are just the breach of contract claim. And again, RLT is owned by Reverse It. It entered into the personal independent contractor agreement with the plaintiffs, and it previously owned the RLA trade name, which it sold to NRF. Reverse It, same thing. My understanding is it's just the breach of contract count that's being asserted against it. Reverse It, just some key facts, was owned by Mr. Shirota. Reverse It purchased RLT stock from the plaintiffs pursuant to the stock purchase agreement, and the purchase price in there was $120,000, and Reverse It paid $122,000 in indemnified debt, as I showed the court earlier. Mr. Shirota seems to be getting it both ways here, both the contract and it also looks like plaintiffs are asserting the tortious interference count against him and the unjust enrichment / trust account, count 3. And again, Mr. Shirota currently owns Reverse It. He previously operated or may still operate Reverse It and RLT. And Mr. Shirota has no contracts with the plaintiff himself. Finally, National Retail Federation, NRF, as we've been calling it, it looks like the briefing is asserting the tortious interference in the unjust enrichment trust account. Again, NRF purchased RLT, assets of RLT, not RLT itself, and the assets of RLT included the RLA trade name, and that was all pursuant to an asset purchase agreement, which for belts and suspenders included assets of any related entities, just to make sure everything was transferred over. So that did include Mr. Shirota, Reverse It Sales, and another company that Mr. Shirota owned. And I'm sure we'll talk more about the asset purchase agreement. So I did not see, and again, I'll address this in rebuttal if Mr. Strauss corrects me, anything in the plaintiff summary judgment briefing about count 5, and maybe I'm misreading that somehow, but so I'm not going to address that yet. I'll just wait and see what Mr. Strauss says. And again, there's the 5 key undisputed facts here that I've listed.
Thank you.
So I want to start with our NRF. Yes, Your Honor.
No, I was just saying thank you. I thought you were done, but please continue.
Almost. I have a few things I wanted to say, and you can tell me to speed up if I'm saying things that you already know. So just to start with NRF, because I do think that's the defendant who has the least business being in this lawsuit. And the situation with NRF is actually similar to the case you ruled on earlier that was related to the bona fide purchasers and the unjust enrichment. It's different because that one was a motion to dismiss, which is a higher standard than the summary judgment motion here, because the plaintiffs have had the entire discovery period and still have no evidence that NRF was aware of any purported unwritten agreement that contradicts the stock purchase agreement and the personal independent contractor agreement. And there's no evidence that the plaintiff conferred a benefit on NRF with the expectation of being compensated by NRF. And of course, NRF therefore did not accept the benefit from the plaintiff. So as stated in our brief, talking about tortious interference, NRF did not act wrongfully because it relied on the contract language in the stock purchase agreement and the personal independent contractor agreement, which do not, by their express terms, prevent RLT from transferring RLT's assets. And that is what the plaintiffs are saying is problematic. The parties in these transactions are all business people who've been working in sophisticated industries for decades. Mr. Vick and Mr. Schroeder are both in their 70s, and they have lengthy business careers. NRF is a big deal and has high-powered in-house counsel. No one in here is an unsophisticated consumer or something that's entitled to any kind of presumption. The plaintiffs have not directly asserted this, but they've said things like Mr. Schroeder's attorneys drafted the agreement, but I don't think there's any allegation that Mr. Schroeder prevented plaintiffs from hiring an attorney, and I think plaintiffs have worked with attorneys, so it's not. I don't think that there's a way to somehow argue that plaintiffs are entitled to a presumption there. And even if it did, that wouldn't apply to NRF, who was just didn't get involved in this till 7 years after that transaction in 2016. So my point is, Your Honor, that generally parties, particularly bona fide purchasers, are entitled to rely on what the contract actually says. And I guess I should say potential bona fide purchasers, because I guess it depends on what that contract actually says to determine whether they're a bona fide purchaser. But in this case, the contracts say or do not say that RLT cannot transfer assets. And you see this type of clause in business purchase agreements sometimes that say, transferring assets will be a default. They're very explicit, and that there is not one of those in any of these agreements. And again, plaintiffs are trying to shoehorn that, what's normally a very express prohibition into Section 16 of the stock purchase agreement. I won't go into that again unless the court has questions, but this non-transferability of rights and obligations in the stock purchase agreement relates to stock and the payment of money for that stock. Nothing to do with IP, which belong to RLT. So that kind of leads me to this fundamental misreading of the contracts that we believe the plaintiffs have. And it's throughout the plaintiff's brief, the plaintiffs refer to plaintiff's intellectual property, plaintiff's company, plaintiff's intellectual property, plaintiff's intellectual property. And this belief by the plaintiffs is based on their notion that there's a verbal agreement that unified and contradicted both the stock purchase agreement and the personal independent contractor agreement. So, that's problematic generally, but it's particularly problematic, like I said, for NRF, because there's no way NRF would have known anything about any verbal agreement. And we've pointed to an absence of evidence on that point. That NRF was entitled to rely on the written agreements. The IP belonged to RLT before and after the sale of RLT to reverse it. It was never plaintiff's IP. It was RLT's IP at all times until RLT sold it to NRF. And while it's true that plaintiff did own RLT, that it was plaintiff's company prior to 2016, they sold it unconditionally. The stock transfer is not contingent on making these years of payment. There's no security interest in there that allows the plaintiff to take the stock back if a payment is missed. The only remedy is for the plaintiff to sue Reverse It for that money if Reverse It did indeed breach the contract, which we dispute. And again, the point is that the sale was final. RLT ceased to be the plaintiff's company when that deal closed in 2017, and RLT was and is Reverse Its company, not the plaintiff's company, as of 2016. So, and I'm sorry, I'm beating a dead horse here. Another dispositive issue on the tortious interference claim against NRF is that there is no interference because no contracts have been breached. And I'll, of course, I'll get into that a little in just a second when I'm talking about the Reverse It and RLT claims. But
so forgive me for
the SPA.
Mr. Knowles, forgive me for interrupting you, but this was announced as 30 minutes, and you're still talking about NRF, and you haven't gotten to RLT or RIT. And so I mean, I did read the briefs, and you guys are entitled to a hearing because you asked for one. But I feel like you are, I don't mean to say you're just because you're not just reading your brief to me. I get that you're just highlighting these specific points, but I feel like I need less granular and more high level, if that helps.
Okay, Your Honor. I'll speed it up. I'm sorry, I lost track of time as lawyers do, and I know it's lunchtime, so it's especially egregious here. And I always talk too fast, and so I try not to do that. But the unjust enrichment count against RF, just really quickly, like that other case you had, there's a 7-year gap here. Plaintiffs did not confer a benefit on NRF. The Boss case discussed by the plaintiffs is distinguishable. This case doesn't involve a right of first refusal or royalties. In addition, but more importantly, in Boss, this is important, the transferred property that the party transferred to the third party is the same property that gave rise to the payment obligation. So in this case, the transferred property, RLT transferring its assets, is not related to the money that was being paid under the consulting agreement, which was ostensibly for plaintiff's work for RLT, or obviously not related to the SPA either. And I actually don't need to talk that long about the other ones, Your Honor, because a lot of what I said just about NRF applies to the other parties. Mr. Schroeder is not a contract party. He's clearly acting as an agent of the contract parties. He's not a stranger to the transaction, as we pointed out in our brief inside the McLean case. And it's also just practically a problem because, the tort claim that the plaintiffs are saying prevents Mr. Schroeder from being protected by the corporate form is tortious interference with a contract that the company signed. So do you see what I'm saying here, Your Honor? He's an agent of the company tortiously interfering with the company's contract. That's just the company breaching the contract. So it's not Mr. Schirotto committing a tort. As far as unjust enrichment, plaintiff cited the Witten case related to Mr. Schirotto. And that case is completely different from our case. In that case, you know, I saw this growing up a lot. You know, somebody has bad credit, so somebody buys the property for them, and the person who has bad credit pays for the property. And the unwritten agreement is that once the payments are done, the paying party gets the property. And Witten, somebody went back on that deal and sold the property that the plaintiff had been paying on. The equivalent or the analogous situation here would be if the plaintiff had retained ownership of RLT while Reverse It was paying. That just didn't happen. So at the beginning, and I'm almost done. At the beginning, I said at best there's a breach of contract case, but even the breach of contract claims are problematic and insufficient as a matter of law. Starting with Reverse It, I think that one's very clear. There's no dispute that the stock purchase agreement was an obligation to pay $120,000, that it said the Rio debt was indemnified by plaintiffs, and that Reverse It indeed paid that $122,000 debt to the Rio Hotel. All of that is undisputed, and that's the end of the story. In addition to that, both Reverse It and RLT have paid the percentage of the RLT revenue that they were supposed to pay. I'll let Mr. Strauss speak to that, and then if the court allows me time for rebuttal, I'll quickly speak on that if necessary.
Okay. Hang on just one second. I apologize for interrupting, Mr. Strauss. Before you get started, I have to go accept the grand jury indictments. It'll take about 5 minutes. I'll be right back, and then I will hear from Mr. Strauss. Thank you.
Thank you.
Thank you, Your Honor.
That whole thing that they were saying I couldn't get off the register. Is that the thing?
No, this would just be this is just the level 1 part.
Right. But didn't I hear that?
Okay. Mr. Strauss, thank you for your patience. I apologize for the delay. And I am ready for your response, Mr. Strauss.
Judge, I'll be brief because I know you've read the briefs, but unfortunately, I disagree. Are you there, Mr. Knowles? I don't see him back.
Okay, well, we definitely should wait on him.
If I'm going to disagree with him, he has to be here.
I know, right? Hang on, I'm going to wait 1 second while we wait for Mr. Knowles to come back. Hang on.
Yes, ma'am.
Hi, Mr. Knowles, are you there?
I believe he's trying to connect to audio. Your
I
Honor.
know. I don't know why that's an issue. Mr. Knowles, are you there? You can't hear us.
Sorry, Your Honor, I lost
There we
lost
go.
audio and didn't realize it until.
Well, Mr. Strauss started off by saying, I disagree with Mr. Knowles, and then realized you weren't here to hear him. So we had to start over again. Mr. Strauss and Madam Court Reporter, we are back on the record after a brief break. Mr. Strauss, your response, please, sir.
Well, it's not only me that disagrees with Mr. Knowles, but it's also his client, Mr. Scirotta, because Mr. Scirotta testified, and I cited this in the brief, that his understanding of the purchase price for my client's company was $1.2 million, and that it was a package deal. Both of the agreements were a package deal together. That he understood that part of the purchase price involved the compensation that was being paid under the consulting agreement. He understood that the consulting agreement was part of the retirement package for the VIX. I think it's interesting to note in the documents that I filed under seal earlier this week, Mr. Scirotta was asked by the General Counsel for National Federation how much work the VIX had actually done under the consulting agreement. And he said, no, they've never done any of the work under the consulting agreement. Again, because the consulting agreement was intended to be part of the purchase price. Interestingly, the payment of the $122,000 hotel debt is relevant to this inquiry as well. Mr. Scirotta indicated that he never, in his mind, that payment of that debt did not constitute satisfaction of the stock purchase agreement. He never contended that. In fact, he said that was just part of the purchase price that would be applied toward the $1.2 million that was owed as part of the package deal.
So, Mr. Strauss, to me, the primary concern for the court when looking at a breach of contract action is, and granted, I get there are two contracts. We've got the consulting contract and then we've got the asset purchase agreement. But both of them have merger clauses, right? And what my understanding is at least Mr. Knowles' characterization of it, is that a large part of the alleged violations that are being claimed by your clients are outside the four corners of the contract and therefore would be barred by the merger clause. So how do you get around that?
Well, if the two contracts are interconnected, then there's not a merger clause problem. If both parties intended, as they both have indicated, that the contracts were interrelated and were a package deal, then there's not a merger clause problem.
No, I guess my point is, if the purchase and sale agreement says, in order to comply with the agreement, I'm sure I'm going to mess this up. Is it RIT or RLT that's the party to the purchase and sale agreement?
RLT.
Okay, so if the purchase and sale agreement says RLT.
I'm sorry, Judge. RIS is purchasing RLT under the stock purchase agreement.
Okay, so if the stock purchase agreement says that the purchaser must do X in order to satisfy their obligations under the contract, then that's what they must do. And additional obligations would not be part of that contractual obligation because there's a merger clause that says this is the whole agreement. Now, to the extent that another agreement exists, even one that's acknowledged, right here, the consultancy agreement, that agreement too says the parties to the agreement must do X. And if it's anything other than X, it's barred by the merger clause. And so I'm not questioning that those two contracts are interrelated, and that together they formed probably the consideration for what your clients understood would be the value of their interest. My point is, what I'm hearing is stuff that sounds like it's outside even the four corners of the consultancy and the stock purchase agreement. And so my question is, how do you get around the merger clause that exists in both of them?
If the parties intended for both contracts to be interconnected and to be complied with together, which is what Mr. Scarota testified to repeatedly in his deposition, then the total purchase price under both contracts is $1.2 million, which is exactly what he intended, Mr. Scarota intended, and what the VIX intended. And
just to be clear, I think I understand, but that 1.2 million total is, you're getting to that number based on the net value of the consultancy payments that should have been made over time. Is that correct?
The value of the consultancy payments, which are $1,080,000
plus the 122 lump sum hotel payment.
120.
Okay.
Yes.
Just making sure I understood.
And actually, what Mr. Kuroda testified is that they actually got there backwards. They agreed on the $1.2 million price for the company and then broke it down in these two separate agreements as to how that price was going to be paid.
Okay.
And so getting back to the payment of the $122,000 for the Rio debt, he indicated that that was just that was applied toward the overall purchase price, according to Mr. Kuroda. And he indicated that it wasn't the entire purchase price; it was just part of the purchase price. Similarly, even after making that payment, if you looked at the two agreements, and Mr. Knowles indicated, the stock purchase agreement has a 0.5% gross revenue payment. The consulting agreement has 4.5%. What Mr. Scarota did was continue paying 5% of gross revenue, even after he paid the $122,000, which was the day after the contract was signed. It wasn't like there was some sort of indemnification claim or something like that. He paid it the day when he went out there to California for the contract to be signed. The other,
go ahead.
And of course, our position is that taking those two contracts together, they've been breached because he's only paid $600,000. There's still another $600,000 that's owed. Also, I do respectfully disagree with Mr. Knowles regarding the non-assignment provision, which is paragraph 16 of the asset purchase agreement. The primary asset of Reverse Logistics Trend is the RLA, Reverse Logistics Association. Both of those are trademarked, and the RLA.org domain name, all of which are now being utilized by National Retail Federation. That's the primary asset that was being purchased by Reverse Logistics, what was being purchased by Reverse Sales, and that Reverse Sales caused to be sold along with Reverse Logistics Trend, caused to be sold to National Retail Federation. And so you can understand why under these two agreements, why the fact that those assets, my client would have an interest in making sure those assets aren't transferred until they've been paid. And so that's why the non-assignment provision is so important. And that's clearly in the agreement. And it was clearly breached. Mr. Scarata obviously certainly indicated during his deposition that he did not get any permission from my clients before he entered into the transfer agreement with National Retail Federation.
But presumably he didn't get that permission because he didn't think he had to, correct?
That is correct.
Okay.
He did say that. Let me talk briefly about piercing the corporate veil. The agreement that Mr. Scarota executed with National Retail Federation provides for his obligation to terminate his companies. And then, so the money that is paid, it's going to be 1.3 million that is paid to him, it's going to him personally. And so I can't think of a more clear situation where piercing the corporate veil is appropriate, where the corporation sells its assets, but the individual owner of the company gets the money, but then there's no company left in order to pursue a claim against. So that's our position in terms of piercing the corporate veil. And I've got a case that addresses that, which is Pope versus Professional Funding Corporation of 221 Georgia Appeals 452. It's an older case, it's 1996, but it sort of lays out the background of the piercing the corporate veil. And it's like here, it's designed to prevent basically unjust enrichment. Now, some of those, and I'll just briefly touch on National Retail Federation, Judge. Some of those documents that I filed with the court under seal earlier this week deal with the negotiations back and forth between Mr. Scarota and National Retail Federation. And there's certain part of that is even asking how much of the $1,080,000 has been paid. In response, Mr. Scarota sends back a list of all the payments that have been made, that showing at that point in time when that they had paid $420,000 toward that. Interestingly, he didn't include the $122,000 in the list of payments that had been made. But so they are certainly aware that there's this outstanding obligation that's out there. I don't see anything in writing where Mr. Scarota says, "Well, I said I was going to pay him $1.2 million," even though that's what he's clearly saying. Now, I suppose they could have asked him. But right
yes,
now,
Mr. Strauss, the what I'm struggling with though, and I think what Mr. Knowles' base point is if the contract doesn't say 1.2 million is the purchase price or the consideration for the stock purchase agreement, but rather that the entry into a consultancy agreement to make payments based on revenue is what was required by the contract, then how do we get, if there's a merger clause, right? Again, all of what you're talking about may sound like good information for Mr. Serrata to present to a jury to determine if there's some sort of dispute, but all of it is parole evidence about external agreements or external understandings of what the agreements meant, when in fact the law says we have these two agreements, we're supposed to look at them.
Judge, a lot of times when you're dealing with this, and it was like your other case earlier too, bona fide purchasers, they specifically asked him what type of work did the VIX do for you under this personal consulting agreement? And he said, they've never done any work for us. And so that sort of is like a bell and a whistle that the personal consulting agreement was part of the purchase price. They should have been on notice at that point in time that that's what the parties intended. And that's what the two agreements read in conjunction with each other, what they mean. Because nobody would be paying somebody 4.5% of their royalties, which going up to that point in time was $2 million for no work if it wasn't part of the purchase price. And Judge, I'm just going to just briefly touch on the smear campaign that was part of the some of the one of the defendants' briefs having to deal with going after Mr. Vick. And as Mr. Knowles acknowledged, that's not really relevant to what's before the court. But if it were before the court, well, actually, it's not really relevant to these motions. So I'm not going to.
I promise that I am capable of ignoring things that the court should not consider when I'm considering the resolution of this summary judgment motion.
Okay. Your Honor, I think those are the highlights that I wanted to make in addition to what's already in the brief.
Thank you so much. Mr. Knowles, if you would like to make rebuttal, you have 3 minutes.
Your Honor, I apologize for talking too long earlier. Do you have any questions for me?
I don't. I think, I mean, in fairness, like I said, this is a case where I think the parties have endeavored to outline for me a very clear recitation of the facts. I don't think anybody got overly flowery or went too far afield of the primary issues. But as I said, ultimately, I'm going to take it under advisement. And what I will do, Mr. Strauss and Mr. Knowles, is when I decide what my ruling is going to be, I will email y'all. And I don't know why there was audio feedback for a second. I will email y'all and tell you what my ruling is going to be and have whoever is the prevailing party prepare a draft order. And then whatever is left of the case, assuming I grant summary judgment as to some claims, as to some parties, or none at all, then we will get set for the next step, which would be a trial on the merits. Where y'all heard me ask this question of others, where are y'all in terms of the status of your case, in terms of scheduling order and relative to trial?
I think we were going to be on the trial calendar for next month.
For May?
We didn't explore mediation, presumably, I guess, because this was pending.
Right.
And so I don't know, depending on what your Honor's ruling is, whether or not the parties would want to mediate. But
okay, well, let me tell you this. I'm going to be out of town next week, but the best I can offer you is that I will do everything in my power to get a ruling to you, even if it's not reduced to an order that I'll ask for from you guys, no later than that next week. I think it's the week of April the 13th. You might get it sooner, but you will have it by then. And then the parties would have approximately a month ahead, just a little less than a month ahead of a pretrial conference and a month and a half nearly ahead of or at least a month and a week ahead of a trial date in May, so that y'all could see about potentially trying to mediate the case based on whatever's left of the case after I rule, assuming that any part of it gets disposed of. Okay?
Yes, ma'am.
Thank you both. I appreciate your time.
Thank you, Your Honor.
Okay. Ms. Crowder, Mr. Pines.
Your Honor, how are you?
Yes, I'm doing fine.
I've never been so happy to be a criminal defense lawyer as I am today. And somewhere somebody owes me an hour or two of my life back. It's
Yes,
not,
and it's probably me.
it's not you.
Ms. Crowder and Mr. Pines, I apologize to you both for it going long, especially given that you have witnesses that have been on standby. So I do apologize for that. Let me start by saying this. I've read the materials that were submitted to me in terms of the judicial packet that was sent to me, which includes some substantive review and assertions by Mr. Pines. I've seen his application. And so I feel like I want to hear from your witnesses, and I'm going to throw it over to y'all in just a moment. One question I do have, I will always take a cat cameo in a hearing.
He was asleep from noon on, I promise.
Well, the civil lawyers and me probably bored him right to sleep.
Yes.
Okay. So, as I said, I have read those materials. And so my first question is, do we want to have argument first and then witnesses, or go straight into witnesses, Ms. Crowder?
I would defer, only because it's his petition. I would defer to Mr. Pines on that in terms of whether or not he wants. He did indicate to me that he may or may not be calling his client as a witness. Other than that, I don't think he disclosed any others.
Okay.
So mine would merely be rebuttals to his.
Okay. And Mr. Pines, do you want to just make argument, or do you plan to call witnesses? And if so, what do you want to start with?
Well, Judge, I'm happy to do, my client's here. He's here. We only have one computer we're sharing. And I was going to put him under oath to talk about some of the things in my letter to SORRB, which obviously you've already reviewed. So I'm happy to do it whichever way the court wants. I don't know if there's specific issues you'd like us to address. I don't know how many of these the court has done. There is a little bit of a kind of novel argument that I told Ms. Crowder about that I would like to raise to the court, and I can do that now, sort of in an opening, so you can understand, you know, where I'm going. But I'm happy to do however you want.
Okay. Thank you, Mr. Pine. So I'm going to do what I typically do with these. So I've probably handled 5 or 6 of these.
That's a lot.
I have, as I said, I've read the materials. I am aware of the general nature of the case that resulted in his going on to the registry. I'm aware that there was a prior alleged incident when he was a juvenile that was part of all of this. And then I'm aware of some of the weaknesses, Mr. Pines, that you've attempted to point to that resulted in, I think, what would be considered a fairly favorable plea arrangement for your client to the charges that resulted in his placement on the registry. And then I think I understand that one of your primary issues is that the leveling that was done wasn't a fulsome reconsideration currently, as much as it was sort of just a rehash of a leveling evaluation that had been done quite some time ago.
Yes, sir.
Okay. So that's what I think I know. Anything that I just said, if it's wrong, please correct me. And if it's not, pick it up from there, Mr. Pines.
No, that's it. I mean, and I'll just be brief, since the court had, well, I will literally be brief, unlike the other lawyers. My client was, the offense date is 2005, which would have made him 17. He's now 37. That's 20 years ago. It's a big difference. He spent some time in custody in his first, when he was arrested, his conviction, when his conviction was overturned, and then as a result of his plea. But he's been in the community at least for 15 years without another sexual offense. The issue in this one, and it's probably one that you've never heard before. So my client is on the registry, obviously because, well, really he's on the registry because the judge ordered him to be on the registry. And that is a part of the sentence in this case.
Right, because he wasn't actually convicted of, by plea or otherwise, a registry required offense, right?
Well, that's debatable. And I think Ms. Crowder would say, well, he actually does fall under 42-112, and that would be a criminal offense against the victim who is a minor, and that is any conduct which by its nature is a sexual offense against the victim who is a minor. And there's actually a case that says cruelty can be a criminal offense against the victim who's a minor, and that is Morrell versus the state 297, Georgia Appeals 592. But the reason why I would say that case doesn't apply in this case is because the victim in that case was 14. So in this case, I think we all agree, and if not, I'll have my client testify to it. The alleged victim was 16. So she was above the age of consent. Now, 42112 says a minor is anyone under the age of 18, which is kind of a little wacky when it comes to this specific area, because cruelty is not a sexual offense. Now, you know, the SORRB and the AG may argue, well, but because she's under 18 and there's sex involved or an allegation of sex involved in the cruelty, it falls under this, you know, what I call a catch-all. And I was trying to think of another situation where you'd have somebody over the age of consent where 42112 would say you'd have to register even though having sex with that person isn't a felony. Because obviously if it's a misdemeanor, there's no registry because you don't have to register for misdemeanors. And the only other statute I could even kind of come up with after searching and searching and searching would be like an interference with custody case. If somebody was their third interference with custody case, which is 16545, where, like, let's say a 19-year-old kept taking a 17-year-old from their custodial parents, because of course, you know, the age, as you know, is 18 for lots of things, and then they had sex, you could say, well, the sex is legal because they're over the age of consent, but it could potentially fall under 42112. Now, nobody has ever litigated the 42112 specific issue that I am raising for the court, so it's completely novel. And it's just important, I think it's important to this court because the directive of SORRB is to, and that's 42114, is the board shall determine the likelihood that a sexual offender will engage in another, and that's the most important phrase, another crime against the victim who is a minor or a dangerous sexual offense. Well, this is not, cruelty is not a dangerous sexual offense. It is potentially, depending on how you interpret it, you know, it could potentially be a crime against the victim who is a minor. But if it's not a crime against the victim who is a minor, I think that kind of, I think, you know, by saying another offense, I think that is just one more of the sort of factors that I think SORRB assumed in this case in when they leveled my client really in 2013, which is when the original leveling was. And so that's the novel kind of argument issue I wanted to raise. I think if you want, I'll just put my client under oath and kind of address some of the issues that I did raise in the letter, which is in the SORRB file. It's Bates stamped pages 052 through 055. But since, you know, some of the SORRB issues were my client's lack of stability in relationships and his lack of stability in employment, and I think a wrong scoring in the static 99R, depending on the questions I have for the two witnesses, the SORRB's witnesses, about how that's scored, whether it's scored at the time or whether it's rescored at his current age. I'll just have him testify to a couple of facts. Is that okay?
Okay. Yes, sir. Go ahead.
All right.
Mr. Higgins, will you please raise your right hand? Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You may lower your hand. Go
Just
ahead, Mr. Pines.
state your name for the court.
I'm Zachary Hume Higgins,
Can you hear him, Your Honor?
Yes, sir.
Okay. And what is your date of birth?
10/28/87,
How old are you?
37,
And back in 2005, how old were you?
17,
And the alleged victim in this case, how old was she?
16.
Okay. You entered an offered plea to cruelty to children in the first degree, correct?
Yes, sir.
Okay. I want to ask you a couple of questions about your relationships with women. Have you been in long-term relationships with women?
Yes.
And how many? How many women have you been in long-term relationships with?
What's your threshold for long-term?
Let's say over 2 years.
2.
Okay. And what are their names?
Miranda and Stevie.
And how long were you in a relationship with Miranda?
2.5, maybe a little more than that.
And what about Stevie?
Stevie was probably a total of 9 years.
And was Miranda before or after you got out of prison for the case in the case we're here to talk about?
Miranda was after.
And what about Stevie?
During and after.
Okay. Are you currently in a relationship?
No, I'm not.
As a registered sex offender, is it difficult to maintain a relationship? The stigma being
it can be difficult to start a relationship.
okay. And is that because you're on the registry?
Absolutely.
Okay. Are you still friendly with Stevie?
Absolutely.
Okay. Did you ever live with Stevie or Miranda?
Both.
And did you ever live with them, either of them or both of them, for more than 2 years?
Both.
Okay. Let's talk about your housing. You currently live with your parents?
Correct.
Okay. And is there a reason why you live with your parents other than it's an acceptable location to live, being on the registry?
I find that I can't ever get past the application for rental because of the sex offender registry. And also because of the sex offender registry, I can't get a job that pays me enough to even think about buying something.
What do you remember when you got out of you got out of prison and then were off house arrest? Do you remember what year that was, roughly?
When I got out of prison or when I got off house arrest?
When you got out of prison.
2013.
Okay. And since 2013, have you been consistently employed?
Every day.
Okay. You've had a lot of jobs though.
Yes.
Okay. Tell the court, like, currently, where do you work?
I currently work for a company called Upstream Inspections. I travel around to different car dealerships and inspect and photograph vehicles and try to get them sold on online auctions.
And how long have you been with them?
With the company, 1.5 years.
And have you been in this field of work before?
Yes.
And who else? Did you work for another company?
I previously worked for a company in the same line of business called ACV for a couple years there.
And there's a reason why you left ACV and went to your new employer?
Perceived better opportunity.
Okay. The other jobs you've had, and I've outlined them all in the letter to the SORRB, so I don't want to go through them. Is there a reason you can give as to why you kind of have gone from sometimes job to job to job?
Well, simply to put it the simplest is that I can't ever get a good job between pay or the work itself. And I've also encountered jobs that will hire me and then within a matter of days, or maybe sometimes it's even been over a week, I'll get a call after I've worked and they say, oh, your background came in or we found something, and I'll be let go.
And is that because you believe you're on the registry?
100%.
Okay. You took a polygraph examination as part of your sex offender evaluation, correct?
Correct.
Okay. And you did get an evaluation with, I believe it was Matthew Connolly, correct?
Correct.
Okay. And at the end of the evaluation, were you ordered to get treatment?
No, sir.
Okay. Are you aware that as part of treatment, in order to progress, you're required to sort of admit what you've done, accept it, so you can then progress to the next step?
Yes, sir.
Okay. And was that one of the reasons why you weren't ordered to treatment? Because you pled Alford, meaning you don't believe you were guilty,
Correct.
but you pled guilty because you didn't want to risk what could happen, correct?
Correct.
And you knew exactly what could happen because the first time you were convicted, before your conviction was overturned, how long were you sentenced to in prison?
35 years.
Okay. That's all the, are you the same person you were when you were 17?
No, sir. I've grown a lot.
Okay. That's all the questions I have at this time, Your Honor.
Thank you. Ms. Crowder, do you have questions for Mr. Higgins?
I only have one question. Mr. Higgins, my name is Elizabeth Crowder. I'm an attorney with the Office of the Attorney General. I represent the Sex Offender Risk Review Board. Your attorney indicated that you are on the registry because the court ordered you to register, correct?
Yes, ma'am.
Did you, and you also indicated that you had entered an Alford plea, is that correct?
Yes, ma'am.
And under the terms of the plea agreement that you entered into, you agreed to register on the registry for the duration of probation, correct?
For the duration of probation, yes, ma'am.
And in that same plea agreement, you did agree at that time that you would register and that your probation would be for 17 years, correct?
At the time you pled?
At the time I pled, my previous counsel indicated to me that there would be a chance after his words were, give it 10 years. And we can see that was explained to me, but yes, what you just stated is correct.
Thank you. I don't have any more questions. Thank you, sir.
Okay. Actually, I do have one question, but it's not for Mr. Higgins. How much time does Mr. Higgins have remaining on probation and or on the registry? I mean, I can do quick math, but nobody really wants me to do that because I'm bad at it. So,
I believe it's 6 years, Your Honor.
okay, thank you.
And I'm happy to give full disclosure. Amanda Clark Palmer represented Mr. Higgins along with Don Samuel when he pled. They went back to attempt to get his probation terminated. Of course, back in 2012 when he entered his plea, we didn't have bid dates. And the court wanted to wanted Mr. Higgins to see if he was a level 1. And so the court indicated, my understanding is the court indicated that if he was a level 1, he would consider terminating his probation, which is why we're trying to get him to a level 1.
Okay, understood.
Yep.
Mr. Pines, do you have any other witnesses?
No.
Okay. Anything else you want to argue before I call on Ms. Crowder?
No.
Okay. Ms. Crowder, do you have any witnesses?
I do, Your Honor. I would call Kirsten Lawhorn.
Okay. Ms. Lawhorn, if you'll raise your right hand. Do you swear the testimony you're about to give the court? Can you raise?
I do.
Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. You may lower your hand. Go ahead, Ms. Crowder.
Thank you, Judge. And before I begin, for convenience sake, if it's okay with Mr. Pines and also with the court, the Risk Review Board did file with the court the entire record that it relied upon. And I am not as technologically savvy as many, and I have difficulty sharing screens.
That's fine.
So for convenience sake, if everybody has the same record, I'm just going to refer by page number, which is in the lower right corner.
And I have 2 screens, so I can look at the page you're referring to on my other screen while you're referring me to it, Ms. Crowder. Go ahead.
Well, thank you. Ms. Lawhorn, where do you currently work?
The Georgia Sex Offender Risk Review Board.
How long have you worked for the Risk Review Board?
Since 2010.
And what is your position at the Risk Review Board?
I'm a clinical evaluator.
Can you briefly describe what a clinical evaluator does for the Sex Offender Risk Review Board?
Yes, my primary responsibility is to conduct risk assessments on offenders, on convicted sex offenders who are being released to the community, and to assess them specifically for the likelihood of sexual recidivism.
And in that capacity, are there tools that you have available to you for use in that process?
Yes, in a standard case, we're able to use 2 structured risk assessments. It depends on the case and the type of conviction, but typically we have structured risk assessments, the static 99R or the static 02R, if they're appropriate for use in the case.
And as a clinical evaluator, how many evaluations would you say that you have done since you started doing this for the Risk Review Board?
Since 2010, I've conducted approximately 4,500 risk assessments.
And do you frequently offer testimony in court with regards to those assessments?
Yes.
Do you take any kind of continuing legal education to keep like your licensing? What licenses do you have, by the way?
I'm a licensed clinical social worker in the state of Georgia and Kentucky, and so I maintain my licensure, and I'm also a clinical member of the Association for the Treatment of Sexual Abusers, which requires me to complete required continuing education courses specifically in the field of assessment and treatment of sex offenders.
Have any of your licenses ever been called into question for suspension or revocation?
No.
You ever been disciplined by any of the licensing boards?
No.
Has any of the testimony you've ever offered in court been questioned or disregarded because you found not to be truthful or accurate with your testimony?
No.
Okay. All right, I would like to talk to you specifically about the case that we're here for with regards to Mr. Higgins. Did you prepare an evaluation for the board's consideration with regards to Mr. Higgins?
Yes, I did.
Do you recall preparing that evaluation?
Yes, I do.
And do you have that evaluation available to review now?
Yes.
Okay. What I want to look at specifically is I want to start with the static 99 form that you made reference to. In this case, was it appropriate to use the static 99 coding form?
Yes, only the static 99 was appropriate in this
Okay.
case.
And just for convenience, why would the 02 form not be used?
The 02 form is not recommended for offenders who commit their offense prior to the age of 18.
Okay. So in this case, you did a static 99 coding form, and that is on page 36 of what was filed by the board in the record. Can you take a look at that document? And one of the things that was mentioned is there's a question as to the scoring here. So I just want to go through this, if you would. Item number 1, there's 1 point. Can you explain why you assessed 1 point for young as to question number 1?
Yes. So even though I conducted my risk assessment in 2024, these risk assessments are static, meaning they capture the offender's risk at time of release from their index offense. So it doesn't ever change. So his age at release into the community, into the risk, would still be the same as it was. So he was 20. He still would be 25 when he was released. So he received 1 point in that area for his age.
Okay. And then there was some, number 2, you also assessed a point in the category or risk factor ever lived with. There's 1 point there, which I assume correlates with yes. Can you
Correct. Yes. So at the time, although it's in part because of his age, although he was young, he may not have had the opportunity. It's still a risk factor that when he got out of custody at 25, there was no indication that he had had a long-term, a 2-year live-in relationship, whether or not he could or he still hadn't had it. And so that's why he would receive that point.
Okay. And then prior sex offenses, skipping down to number 5, you gave him 1 point there. And can you
Yes.
explain that point?
He has an adolescent sex offense arrest.
Okay. And then number 8, you gave him 1 point for unrelated victims. Can you explain that one?
Well, the victim of the index offense, of the most recent known sex offense, was not related to him in any way. So she would be considered unrelated.
Okay. And so he, according to this static 99 form that you prepared, he came up with a 4, and that correlates to what?
That would be considered an above average risk.
Okay. And then, so then once you prepared this form, what is that number? How do you use that number in determining overall risk?
Well, that's kind of a starting point, looking at what their risk is at time of release. Well, then you start looking at the factors in terms of what has happened since that time. So those would be the dynamic factors, their behavior in the community, their treatment, all the things that have happened since that release and since that static score, which won't change.
Okay, I want to talk to you specifically about 2 things that were mentioned by Mr. Pines. The first one is that there was a polygraph exam that was done. It's in the record. I just want to make sure that there's no question. When you did and conducted this evaluation, did you take a look at and consider that polygraph exam that you had that was provided to you or the board for consideration?
Yes, I was able to review that as part of my 2024 evaluation.
And can you explain just briefly for the court why it is that that particular polygraph, I'm assuming since he remained a level 2, didn't impact your recommendation to the board that he be at level 2. Is that a fair assumption first?
Yes, well, that was one factor. The polygraph had been quality controlled and there were noted concerns about the type of questions that were asked. But there were other factors there that contributed to me determining that he was still at a level 2.
Okay, can you explain briefly what those were?
Well, although there had been time free in the community, I had because about 10 years had lapsed, I had the ability to look at 10 years of community supervision notes. And during that time, some of the things that came up was that there were lengthy periods of time in which he was avoiding being in treatment. And we're talking years, 4 years where he was supposed to be going to treatment and he wasn't. So, I mean, we're talking about he first goes through an evaluation in 2014. He doesn't actually go back until 2020 when he is told, you better go back and complete your evaluation by his treatment provider. So to me, that this is not somebody who is complying with what's asked of them during this time in terms of treatment. Then he goes to the, he undergoes the evaluation, at which time, he does acknowledge having a prior sex offense as a juvenile during this evaluation, and which is which is an indicator of risk. So that concerned me. Also, despite the fact that treatment was not recommended at that point, the treatment provider did recommend that the offender undergo polygraph examinations, periodic polygraph examinations. This is none of which he did. So we really haven't had the benefit of monitoring his behavior in the community because he hasn't had that type of monitoring that we typically have. And in terms of the relationships, I did see that there was relationships over the past 10 years, but there was no indication of a 9-year relationship. And it's noted in my report, I can see that he would live with somebody and then there was some moving around, but there was never anything submitted suggesting a 9-year long-term relationship in the probation notes. So those were the things that over the 10-year period led to me still landing at a level 2.
I don't have any further questions for Ms. Lawhorn, Judge.
Okay, Mr. Pines?
Thank you, Your Honor. So, Ms. Lawhorn, did you actually ever look at a copy of my client's sentence?
Yes.
Okay. He was not ordered to get a sex offender evaluation. According to the sentence, he was ordered to get a mental health evaluation, or actually a mental evaluation. Is that correct?
I don't have it in front of me.
Okay. It's SORRB page 007 for the court in Ms. Crowder's reference. But would that change your opinion to know that he was actually never required, according to his sentence, to get a sex offender evaluation, but that he was just told to get a mental evaluation?
No, I just saw that his probation officer directed him to, and he did not follow with her directives. That was the notes I saw.
And when did the probation officer direct him to do that? Do you know?
According to my summary, he was notified he would be required to complete the evaluation. He did not return until October of 2020.
Obviously, there was no probation violation for failing to complete.
No, there was no probation violation.
And despite maybe him not completing the evaluation that was done by Mr. Connolly until 2020, there were no reoffenses during that period of time, correct?
No known reoffenses, correct.
In the polygraph examination itself on page 1, which would be page 037 of the SORRB filing, at least Mr. Higgins reported that he lived with his girlfriend, Stevie, at an address in Noonan, Georgia. So that was information you had available to you. And on the next page, which is 038 of the polygraph examination, Mr. Higgins stated he's never been married, but is in a committed relationship with his girlfriend of 9+ years, Stevie, age 33.
I see he stated that, but that wasn't what the notes reflected, that he didn't reflect that he was living with her. It's about live-in lover of 2 years is specifically what the question addresses.
Okay.
So
But,
no,
I mean,
I note in my report that he has in community supervision behavior, it's noted that he's living with his girlfriend
okay,
in there.
got it. I know we're talking about the static test. So static O2R is not available because he was a teenager.
He was
correct?
17.
17. And so static 99R, you're saying that the fact that he was young is never going to change. So you're not reevaluating him now. You're saying at the time he was young. So no matter
His
what,
score will never change.
correct, he gets a point. Then you also said that he, at least at that point, the time that you did the evaluation, or the time, it would really be the time of the commission of the offense, or I guess it's the time that he was released. He hadn't lived with a lover for over 2 years, and you did your evaluation in August of 2013, right?
I did not.
Well, I'm sorry.
Haley did. The other Haley Entrican. Yes.
I collectively refer to SORRB, so I apologize.
Okay.
SORRB did the evaluation August of 2013, which is when my client was released from prison. So, I mean, in essence, he's getting dinged for a point for being in prison and not have lived with a lover. And before that, he would have been a teenager. So
It's not a ding, it's a risk factor. A risk factor is a risk factor, whether he had the opportunity or not.
okay. And you also counted a juvenile delinquency adjudication as a prior sex offense, correct?
An arrest, yes.
Okay. Well, juveniles aren't arrested, so.
He reported he had received services. He reported criminal justice sanctions for a sex offense as a juvenile.
If his score was, like, if you were rescoring him today, right? He would you'd at least knock 2 points off and he'd be a 2 instead of a 4, correct?
No, I can't rescore. Okay. I can't change the score. I can depart from the score in his assessment, but you're always supposed to score it based on their age at release. So I cannot change the age. I can depart from the scores.
Okay. Did you depart from the scores?
No.
Okay. If you were scoring him new today, he got out of prison yesterday, right? And all the factors are the same, and you accept, obviously, now that he's 37 and that he has lived with a lover for 2 years, he would be a 2, correct?
I can't answer that question. Can you ask that again? Yeah. I'm sorry, I didn't understand it.
All things the same, except he just got out of prison yesterday, so now he's 37.
Well, no, his score would be different if he was getting out yesterday. So I can't answer that.
According to the static 99R scoring or just your manual, there is, I guess, I don't know if it's a theory, it's the time in the community. And according to the manual, for every 5 years you're in the community and you have not reoffended, your chance or risk of reoffending in essence halves, correct?
In general, for a low risk sex offender, yes.
Okay, so if he's been in the community now for 15 years, that would be, and he was 100% chance to reoffend. We'll do a little bit math, but
he is not a low risk sex offender. He is most juvenile sex offenders who have treatment do not go on to commit subsequent sex offenses. That's not the case with him. So he is not the typical, he is not a low risk sex offender who has 10 years free.
So you're
He's not
counting,
starting off as a low risk. He has additional risk factors in this case, which make him a higher risk.
and you're counting the cruelty that he got sentenced to under Alford as a sex offense. Even though the victim is
Yes, his
17.
conviction, yes.
Okay.
That made him have to register, yes.
Well, his sentence made him have to register. The judge made him have to register as a part of his sentence, right? I mean, the victim in this case, or alleged victim, was not under the age of 16, so it was not any sort of actual ability to consent. And while he was originally convicted of more serious charges, he was convicted of cruelty to children, which is causing her, mental pain or physical pain, not necessarily sex offense. Correct?
What was the question?
It's okay.
I
I'll
don't
move on.
Can I
Okay.
interrupt actually, Mr. Pines, and ask a question? Mr. Pines is focusing on the offense that Mr. Higgins was actually ultimately convicted of, which was that cruelty to children offense. When SORB is doing an assessment, are you looking at the either alleged or proved facts of the underlying sentence, or are you only looking at the offense?
Are you asking,
Yes, ma'am, I'm asking you.
Yes, okay. No, we do not look at it's not about the charges or what they're convicted of. We look at the offense behavior and the totality of the situation.
Right, so you are looking at the underlying allegations, whether proved or alleged.
Yes.
Not necessarily the actual charge for which the individual entered a guilty plea or was convicted.
In terms of scoring purposes, we have to go with what you're talking about, the plea. But when we're looking at the overall picture of an offender's risk, we look at more than just what they were convicted of. We look at the bigger issue of risk of what is the offense behavior and what are the patterns of offending that might exist.
So may I ask a follow-up question to that then, Your Honor?
Feel free. I'm sorry to interrupt. I just wanted to clarify that.
Actually, asked a great question. Typically, when you're looking at the offense conduct, so behind the charge, you have a defendant or somebody you're evaluating who's saying, I'm guilty. I admit that the facts alleged by the victim are true and accurate. And that is sort of how you base your opinion of a risk assessment, correct?
No.
Okay, so you don't.
We don't base our risk assessment on whether an offender admits guilt.
Hang on, I'm going to interrupt one more time. I'm sorry, Mr. Pines. So am I understanding if you're focusing on the offense behavior, which is what is alleged, the underlying alleged behavior, you're assuming that it is true, whether it has been proved true or admitted to be true or whatever, you are just accepting that for what is alleged, correct?
We're identifying the risk factors that might be, not the degree of harm and those kinds of things.
Sure.
Like the victim age, the things that we, as much as we can, that's identifying, that's as.
Okay.
Yeah, but we try to keep it as objective in terms of like whether they did it 5 times or 2 times, that kind of thing we don't typically get into.
Okay, fair enough. Sorry, Mr. Pines, I'm stepping on the examination.
Actually, that's another great question, Your Honor. So the fact that he entered an Alford plea doesn't really impact the way that you did this evaluation.
I received a notification that I was to assess from the courts that I was to classify this offender for risk. That is that's where my role starts, to classify him for risk.
Okay, like whether he did it or not.
No.
Okay.
Not whether he did it. He's already been convicted in a court. It's coming to me to assess him for risk.
Right.
That's my focus. It's not about what he was convicted. It's looking at his behavior in the community, his prior, the whole totality of the case to assess my assessment of the likelihood he could commit a sexual reoffense.
And based on his behavior in the community since 2013, there's not a risk factor that you can cite to this court that would make him a level 2.
There's not risk reducing. He scored as a 2. And I do not see that in this case, his risk has decreased to that of a 1.
And that's based on the relationship stability.
No, it's based on him being a juvenile offense. He has a juvenile sex offense and adult sex offense. He is not he completed treatment as a juvenile and reoffended. He is already, I mean, he didn't participate in sex offender treatment as an adult, whether it was recommended. I mean, he didn't participate. He did not get follow-up polygraphs to monitor his behavior while he's been under supervision. So while he says he's been compliant, I mean, oftentimes when people are in treatment, we have the benefit of the monitoring polygraphs to add some validity, but he has not had any type of maintenance during this time. So I don't, and the treatment provider specifically recommended that he undergo periodic polygraphs.
And he also recommended that he not complete treatment, that he not have to complete treatment, correct?
He did not say he didn't have to complete treatment. He said he wouldn't, I mean, he said he wouldn't be an appropriate candidate based on a polygraph, which has since had a quality control and shown that there are some issues with the question. So
I didn't mean to cut you off. I apologize.
no, I'm just saying, so those are the reasons that I settled on a 2 as of 2024.
Got it. And you are aware that part of treatment is admitting that you did the allegations in there, and that the issue in an Alford plea is you didn't admit that.
I was a treatment provider for 12 years, and we had offenders who did not admit their offense.
And you still progressed them through the program?
They still participated in treatment in some way.
Did you progress them though?
What do you mean by progress?
Like they actually move on in the I'm just asking because typically you won't progress in treatment and be allowed to complete treatment unless you admit what you're charged with.
I don't know how that treatment program operates, that, you know, but I've worked with many individuals who accepted Alford pleas, who continued to deny their offense and who later admitted their offense. So what somebody pleads in court is a different issue than what they need to be working on in treatment.
Okay, that's all the questions I have at this point, Your Honor.
Thank you. Ms. Crowder, anything else for this witness?
No, thank you, Judge.
Okay, thank you, ma'am. You are excused as a witness. Ms. Crowder, do you have any other witnesses?
No, Your Honor.
Mr. Pines, anybody in rebuttal?
Can you just give me 1 second?
Sure.
Ready to argue, Your Honor.
Okay, go ahead, Mr. Pines.
Do I have, I can't remember. I guess I have the burden, right? Do I have the burden?
Wait, well, I mean, it's your motion.
I'll go first.
So I'm gonna have you go first and then I'll let Ms. Crowder respond and then
Sure.
you get the last word, sir.
Sure. So, Your Honor, again, I mean, what you're required to do today is to determine, based upon the preponderance of the evidence, if my client is in the right category. And I would say that he is not in the right category, that he should be a category 1. I laid out everything, I think, pretty succinctly in the material I sent SORRB. I think you asked some very good questions today. It's, Mr. Higgins is sort of being, I'm going to use the word punished. No, I don't know where punished is right. He's sort of stuck in the time of, well, these static things are from when you're 17 and you were a teenager then. And so we're not going to change those, but we're going to hold everything bad against you that happened when you were 17 and 13, and we're not going to give you any credit for the stuff you have been doing. And it's kind of, to me, it's kind of like field sobriety evaluations. When you do field sobriety evaluations, I explain to people, it's not like a math test where you got 10 questions, you get 8 right, and you get 2 wrong and you get an 80. It's, you know, when you do 8 things right and 2 things wrong on field sobriety evaluations, you get -20. And I understand potentially for the way he was evaluated in 2013, he had just been released. He was 25 years old. He did not establish himself in the community. He had not had, you know, the evaluation, the polygraph. He had not had employment. He had not had that stability. But you know, we're talking 17 versus 37. And, you know, I was a much different person at 17 than I was 37. Most importantly, he showed that he is, you know, not a risk to reoffend by his time in the community. So now he's been in the community for at least 15 years without committing a subsequent offense. I think that does prove that he is not a substantial risk to reoffend, or in this case, that he is a sexual offender who will engage in another crime against the victim who is a minor. And I'm going to go back to my original argument, which is the crime of cruelty is not a criminal offense or crime against a victim who is a minor because of the age of the victim in this case, or alleged victim in this case, who is 16 years old. So I think that if the court, you know, would look at the totality of this, what he pled to, the fact that it was an Alford, his time in the community, the fact that he's been on probation without, you know, another offense that he did complete, what, you know, and the sentence is what the sentence is. It says mental health. Now, why did it take longer to get a psychosexual? That could be something his probation officer told him to do. But there's a big difference, as you know, between a mental health evaluation and a psychosexual. But he completed it, and he completed a polygraph. And I understand SORRB doesn't like the polygraph, but it was completed. You saw the questions that were asked. I think they were appropriate questions based on everything. And so I would ask this court to find, by preponderance of the evidence, that my client should be a level 1 offender, not level 2.
Okay, thank you. Ms. Crowder?
Thank you, Judge. The first thing I would say is, while I understand that Mr. Higgins is on the registry, Mr. Higgins entered into an agreement with the state in exchange, and I understand he also entered an Alford plea, but he entered an Alford plea in 2013. So he was no longer 17, obviously. If he was 17 in 2005, he was 25 maybe in 2013 when he entered an Alford plea and entered into an agreement, a plea agreement, a negotiated plea agreement at that, for a 20-year sentence, as opposed to going and running the risk of going to trial again and potentially getting maybe another 35-year sentence. So while I understand all of those facts, it is part and parcel of what he agreed to in exchange for not having the risk involved in going to trial and potentially being found guilty again. So while Mr. Pines makes great note of the fact that he's on the registry because the court ordered him to be on the registry, it was really an agreement that was put before the court as a negotiated plea. But that being said, there is also the case that Mr. Pines made reference to, the Morrell versus State case from 2009. And it is different in that the victim in that case was 14, but it is not different in that the individual, in fact, did enter an Alford plea to a charge of cruelty to children versus an actual sex offense, and ultimately tried to get the conviction set aside and not have to register by virtue of that. And the court said that that was a no-go, that even though you did enter a plea and an Alford plea is akin to a guilty plea. It's just you do have to admit guilt. You don't have necessarily the same outcome, but you're doing that admission with understanding that you don't want to risk a different outcome. But that being said, I think the Morrell case is pretty much on point in terms of whether or not the cruelty to children charge should be something that the court should consider, and whether or not he should remain on the registry and a sex offender, and so forth. But that being said, Mr. Pines also argued in his correspondence and his primary argument with regards to the static 99 that it was improperly done and that it was improperly scored. And as a result of that, it should be a 2, which would in fact lower his level. I believe that Ms. Lawhorn explained that the static 99 is never going to change. And in fact, based on her testimony, the static 99 form was in fact accurately prepared at the time that it was prepared, both in 2013, and because it's never going to change, remained the same in 2024.
Well, I think what, I mean, I absolutely have zero clinical experience of any kind and would never, ever attempt to imply that my estimation or evaluation would in any way supplant someone with the clear experience, education, and training that Ms. Lawhorn has. But here's what I don't understand, to Mr. Pines's point. I'm looking at the static 99 coding form. And if in fact y'all are correct that I'm looking at the one that I guess was originally done and the one that was done more recently. And if Ms. Lawhorn is correct that it's all based on the time of offense, then what's the point of ever redoing it? Right? Because the fact that he was young when the offense occurred is never going to change. He was 17. The fact that at the time this evaluation was done, he'd been in the criminal justice system and or too young to have had the life experience to live with someone is never going to change. And the fact that he had a prior sex offense, never going to change. And the fact that he's never had an unrelated victim, never going to change. And so, well, except to potentially get worse, right? If he went out and committed other offenses. But I guess that's the problem I have, is if it's all tied to when he was, to the time of the offense, then what's the point of even redoing an evaluation ever? Because these factors are never going to change, and he's always going to be at least a 4, which would seem to be unfairly punitive against someone who was, say, in their teens or early 20s when they commit an offense versus someone who's 30 or 35 when they commit an offense.
I would say 2 things. One, while I understand it, there has to be a starting point, obviously. And so that's the benefit of those forms. They do give a starting point, but as Ms. Lawhorn explained or testified to, you know, there are methods and there are factors that are dynamic factors. This is a beginning point, and while it is never going to change, it does allow flexibility, and dynamic risk changes, and therefore the kinds of things that allow you the opportunity to deviate from that form itself. But there always has to be a beginning point. Otherwise, we're just like, I mean, where do we start at ever? I mean, you know, you have an index offense.
No, I completely understand. Right. But I guess my
at the moment, that's the best we have.
No, again, I hesitate to even argue with you about it because, again, I don't have clinical experience, and I definitely do not mean to supplant that experience, my legal experience for the clinical experience. But the age at the time of offense absolutely makes sense. That would be whether someone was young or older when that offense was committed, completely makes sense. But whether someone has ever lived, right, with someone, it seems to be unfairly punitive if it's tied directly to the time of the evaluation or the time of the offense, or excuse me, at the time that they're coming out. Because I'm just imagining a circumstance in which somebody who's 36 commits a heinous sexual offense, and they've been married for a long time, and they get a 0 and a 0 on points 1 and 2. And maybe they had a prior sexual offense, so they get a 1. But they end up with a lower score than someone like Mr. Higgins. And that just doesn't quite make sense to me. But again, I don't want to supplant my judgment for the judgment of the SORB. And that is not what I'm intending to do. I promise, even though it may sound that way, Ms. Crowder. Please
Oh,
continue.
no, I didn't perceive that in any way. The only other thing I would say is that I believe that, you know, the burden is on Mr. Pines, or well, obviously on Mr. Higgins via Mr. Pines, to demonstrate that the risk review board got it wrong. The testimony of Ms. Lawhorn, and from the perspective there's nothing in the record, and you know, I mean, it was pretty clear from the assessment that was done by Ms. Lawhorn where the concerns lied with regards to the Mr. Higgins remaining, or why they assessed him and continued to leave him as a level 2, or assessed him as a level 2. His response to that, in all fairness, was to say, I think you're wrong, and you got the static 99 wrong, and you shouldn't have pointed, you know, scored it that way. And that, yeah, he's got a lot of jobs, but he's a convicted sex offender. And because he's a convicted sex offender, he's had to have a lot of jobs.
Well,
I don't think that in and of
ask you
itself,
a
I mean, he
question,
didn't
Ms.
submit any
Crowder.
documentation.
Let me ask you a question. So let's say that I were to deny Mr. Higgins' request to be reclassified or to have him, you know, reevaluated. And to say, and he came back 2 years from now and said, I'd like to be reevaluated. What is going to change? What could possibly change in the next 2 years that might change the SORB's evaluation if the static 99 is always going to be a 4? Going forward?
Well, arguably, that would depend entirely upon Mr. Higgins and whether or not Mr. Higgins did anything, provided any additional records, did anything. You know, I mean, one of the things that Ms. Lawhorn pointed out in her evaluation is the concerns with the polygraph that was done. And therefore, I mean, and to be honest with you, Judge, it's not common, at least in my experience, and I've only done about 15 of these, but for them to have quality controls done on polygraph exams and things of that sort. And so I think in this particular case, that is telling in that the board really looked very carefully at what was in front of them before they just, you know, made a decision that Mr. Higgins should remain a level 2. And they pointed out,
as an aside, I mean, I think a lot of y'all are making a lot of hay with this polygraph and whether it was valid or not. But I mean, if you just completely throw it all out, right? You still have the sexual evaluation. You still have the static 99 report that Ms. Lawhorn is conducting. You still have the fact that he hasn't had any other offenses. You still have the same work history that he's provided. You still have the same relationship history that he's provided. So I don't know that the existence of the polygraph or perhaps calling it into question really changes the outcome. Because to me, if you just pluck it right out, it doesn't really change the universe of facts that we all have to work with.
No. I agree with you, Judge. I mean, the most candid answer to your question is 2 more years. That's literally what you have is a 2 more years.
2 more years will have passed.
Yeah, 2 more years have passed. I mean, that's really, I mean, in the sum and substance of a lot of the evaluations and the kinds of risk, I mean, you know, the reason that the age at release is a factor is that the younger you are, the more time you have to create, to do another sex offense. I mean, it's like kind of the converse of it. It seems like it would be a positive, but it's kind of a negative in that the realm of possibility is greater for you. You have more time on the planet to do these things than people who are 60. And so the age at release matters in that context. But all of that being said, the only thing that you ever have is the additional passage of time. And, you know, in evaluations and things, I mean, I don't know. It's very difficult to say what could occur in the next 2 years that may or may not change the outcome because it's kind of hypothetical, but certainly good and bad things could occur.
Well, and I think, Ms. Crowder, my last point on that is, I think what I'm struggling with is I agree with you that if bad things happened, the evaluation, that very likely bad things could happen that would change the assessment of the SORB of Mr. Higgins' classification level. What I'm questioning though is it sounds as if good things could happen too that wouldn't change the outcome of the SORB's leveling evaluation. And that's what that seems inequitable. Anything else, Ms. Crowder?
Nothing, Judge. Thank you.
Mr. Pines? You're muted, Mr. Pines. It would not be a Zoom hearing if I didn't have to say that at least one time.
There we go. I'm happy I could do that for you. So to get to your point about the static 99R, Your Honor, because it is at the time of release, according to what I understand from the testimony from Ms. Lawhorn, that means that, kind of jumping on your hypothetical, if my client had been sentenced to like 25 years in prison and got out at age 35, he would not get a point. He'd be 0 because his age at the time of release would be 35. And so because he was locked up in prison, according to the static 99, he'd have one less point. So that's what I'm trying to say. He's been now in the community, which is a better place than prison, because it's obviously harder to commit a sex, well, maybe it's not harder to commit a sex offense in prison these days, but
nope,
it's
it's probably not.
One. But it's exactly what you're saying is like, okay, now why would he get 0 points if he was in prison for 20 years? That doesn't make any sense. And I know Ms. Crowder said that he agreed to his probation sentence, which he did, and to register, which he did. And I'm not asking you to take him off the registry. That's not what we're here to do. That's not a decision you're doing. He will remain on the registry. He will remain on probation. That's a different issue for a different judge. That would be the judge who sentenced him. That's not what you're being asked to do. I'm asking you just to reclassify him as a level 1, not because of that reason, but because I believe the evidence supports it. And I did present evidence. I know that when they reevaluated, or at least looked at what I sent on page 051, the last paragraph is, in addition, as a reoffender, there's no strong evidence to suggest he has established a stable lifestyle. And he's incredibly stable as a sex offender. Being a registered sex offender is really hard. I mean, I tell people when they have the choice, I'm like, you should go to prison for a couple of years if I can help get you off the registry in the end, because it is very easy to get rearrested as a sex offender, not to be able to keep employment, not to be able to keep a residence, to kind of get in this cycle. It's a vicious cycle for sex offenders because it's so restrictive on what they can do. And he has an incredibly stable lifestyle. And that's one of those dynamic factors that I believe SORRB did not take into account, along with the other factors that I listed in my letter.
Thank you.
Thank you.
I don't enjoy this position because although I'm not being asked to remove anybody, honestly, I would be more comfortable being asked whether someone should or should not be on a registry, because that feels squarely like a legal decision that I can live with. And instead, what I'm being asked to do is to, I mean, as much as I keep saying that I don't wish to substitute my my legal judgment for the SORB's clinical judgment, that's basically what I'm being asked to do, in the sense that I'm not being asked to say, no, this should have been a different outcome. But at a minimum, there are factors here that have been presented to me that, by a preponderance of the evidence, demonstrate there might be a different outcome had those matters been taken into account. Now, the issue is, and this is where I do have a question for you, Mr. Pines. I mean, I understand what the standard is, but what exactly is the relief that you seek? Is it that you want me to order the SOB to re-level him, as in a different evaluation? Or is it that you want me to order them to remove their clinically informed, albeit perhaps based on insufficient or inadequate facts, or inaccurate facts, to substitute my judgment for their clinical judgment and tell them, no, he's a level 1, not a level 2.
Sure. So under 42-114, your duty or your determination, and it's paragraph C, Your Honor, and it's
Yes,
kind of
sir.
halfway down. It says, it just talks about what we do in the hearing, and it says the court may uphold the classification of the board, or if the court finds by a preponderance of the evidence that the sexual offender is not placed in the appropriate classification level, the court shall place the sexual offender in the appropriate risk assessment classification. And then you, that's it. So you would issue an order. That's the only thing you can do, according to the statute. You determine whether he is, based on what you've heard, which is taking into account that, and what I would say also is that SORRB has been given the level of respect, legal respect that you're kind of talking about, in the fact that, you know, what they submit is prima facie evidence. So, and then we have to have the hearing. You determine by preponderance whether, based on everything you've heard, whether my client is in the correct risk assessment category or level. And then if you find by preponderance that he's not, then you basically issue an order, and that order would say, by preponderance of the evidence, I hereby find that Mr. Higgins should be a level 1 offender. And if you find against this, you say that you don't find by preponderance of the evidence, or you find by preponderance of the evidence that he's in the right risk assessment category. Did I get that right, Ms. Crowder?
Yes.
Okay, thank you, Mr. Pines. I want to back up for a moment because I did ask a number of questions about the static 99R form, and obviously that's sort of the squarely. It sounds to me as if my decision is that Mr. Higgins should be recategorized as a level 1, it needs to be based on a finding of by a preponderance of the evidence that there are factors, I guess, that were not taken into account, or that could have, should have, would have changed the outcome. Here's what I am persuaded by, whether it's the 1099R form, whether it's anything else. It's that Mr. Higgins has demonstrated his ability to have 2 long-term relationships and other factors that demonstrate stability, which I don't think was fairly accounted for in the assessment that placed him at level 2. And ultimately, I find by a preponderance of the evidence that I've heard that Mr. Higgins is not appropriately categorized as a level 2, or excuse me, classified as a level 2, and that he should be classified as a level 1 pursuant to OCGA 42-1-14C. Mr. Pines, will you please provide me with a proposed order that I can edit and then get on file for everyone?
Yes, Your Honor.
Okay.
Would you like me to send it to Ms. Crowder first, or just send it directly to everybody?
You're free to send it to her, or you can send it and just copy her, and then if she has concerns about it, she can let me know. But if it's, obviously Ms. Crowder disagrees probably with my ruling, but to the extent that you want to check with her first and confirm that that your order accurately reflects the sum and substance of my ruling. Keep in mind, however, that it is a draft, and I don't always, I try not to, but I don't typically just sign it. I sometimes will edit it and make sure that it reflects what I think, but it's easier to edit than it is to create from whole cloth. So you make sure that Ms. Crowder is in the loop, and if she has concerns, she can let me know, or she can let you know before you send me.
Yes, Your Honor. Am I sending that directly to you or your staff attorney?
Mr. Freehoff, mitchell.freehoff@fultoncountyga.gov, and make sure it's in Word format so I can edit it, and that will be it.
Yes, Your Honor. Thank you.
Okay. Thank you all for your time. Again, sorry for the delay today. I appreciate